my lord. I have, my lord.
2014 matter.
Sorry, my lord. 2024, my lord.
24 matter.
24, my lord.
What is the subject matter?
Subject matter regarding selection of a constable of PRPF.
Sorry, not a matter for out of turn listing. Sorry. Yes.
May it please the Lord. If I beg for listing of one pending writ petition 2020,
21.
Okay.
What is the subject matter?
non-payment of salaries
21. Okay. 21 next Monday.
next Monday.
May it please the Lord. If I beg to mention for listing of a 2014 matter.
14.
14.
Okay. We'll
Hearing matter.
14 will have it on the Friday. We'll fix a date for hearing.
This Friday, Lord.
Yes. Or this Friday or Monday, whenever you. 14 matter.
May I please,
Highly
Your
observed.
Lordship, with the consent of the other side, I beg to mention item number 14.
1-4.
Yes, sir.
Yes.
Mr. Sharma is facing some health issues. I kindly pass over the matter for the day, Lord.
Ms. M. Sharma.
Yes.
For the bank.
Yes.
And other side you have informed.
Please, sir.
Okay. Yes. Anything? Hmm?
On top of the
Yes. What you were saying something? Okay. It is submitted. That's okay. It is submitted. That's M. Sharma, learned counsel for the respondent bank is unwell. Para? Unwell, and accordingly, a prayer for adjournment has been made. Para? List when? After 2 weeks? List for hearing after 2 weeks.
Much of it, sir.
Yes.
Lordship, we have filed an IA in and pending writ petition, Lord. Kindly allow me to.
You have filed it.
Yes, Your Lordship.
When do I for what?
IA for impeachment of party, Lord.
Okay, we'll have it Monday next.
May it please your lordship, I beg to mention writ petition for listing
What is the stage?
motion.
Motion is Monday or Friday?
Friday.
Filed or not?
File. Oblige.
It's on.
Right, please. First, will kindly peruse the lawsuit order dated 29/7/20.
The suspension matter. Yes.
Yes.
Yes, Malad, I have been informed, Malad, they are taking more time, Malad. They haven't completed the departmental proceedings, Malad. Second so was issued, Malad, and inquiry report also provided to him. But
What is your instruction?
My lord, inquiry report was furnished to me and I have replied to that, my lord, and they're sitting over the matter. And no review, not even a single review has been done. So it is a case, my lord, lordship will interfere with the suspension order and issue direction formally.
Liberty.
Let them take their time.
How much time will you need?
So they are saying, Malad, just now I have received, Malad, 20 days. But this is a 2 week time, Malad.
More than 1 year has passed, I am under suspension, my lord. Let them take time, I don't. But lordship will
Let
interfere
them,
because
Malad,
no review, my lord.
another 2 weeks.
And they are violating their own process now, my lord.
So to take up the matter, Malad, because they are paying, Malad, time. They have already done.
If he has given the response to the second show cause notice, you take a call, pass final orders, matter ends there.
Yes.
If he's aggrieved, he comes before this court.
Yes.
But why do you?
In fact, I informed them by written, Malad. I informed them to take action, Malad, within 10 days. And otherwise, Malad, failing which honorable could take the matter as per available report. I
Yes.
have informed it. Now, today I received a Malad, Sebas. They are paying.
What is the allegation?
My lord, the petitioner worked as a Latmandan in the circle office, Kamalpur Revenue Circle. One of our colleagues, my lord, was caught red-handed while accepting bribe, and he implicated me, my lord.
The mention of fraud, okay. Let them have chance, Malad, complete it, Malad. Another, at least 2 weeks time.
Heard Sri J. Patwari, learned counsel for the petitioner. Full stop. The matter relates to a challenge to an order of suspension from service. Full stop. It is the specific allegation that there was no periodic review of the suspension order dated 5/4/2023. Full stop. Para. When the matter was listed on the last occasion, that is 29/7/2024, comma, this court was informed that the inquiry was over and the second show cause notice was also responded to by the petitioner. Full stop. Under those conditions, comma, on the prayer made on behalf of the respondents, comma, 15 days time was granted to pass final orders with further observation that in case no final orders are passed within the said time, comma, the petitioner would pray for revocation. The petitioner can revive the prayer for revocation of the order of suspension. Full stop. Para. Shri P.C. Chutia, learned additional synagogue advocate Assam, has however submitted that though instructions were given for completion of the disciplinary proceeding in terms of the earlier order, comma, some more time has been prayed for. Full stop. Where were you serving?
I am serving as a lot mandal under the office of circle officer Kamal.
The allegations prima facie pertains to illegal gratification. Full stop. More than a year has passed since the order of suspension, and it is a matter of serious concern that the department proceeding is not yet over. Full stop. Para. In view of the aforesaid facts and circumstances and the observations made by this court in the last order dated
29/7.
29/7/2024, comma, this court has no other option but to examine the suspension order, the validity oblique legality of the suspension order dated 5/4/2023. Full stop. Para. The law is well settled in this field by a catena of judgments of the Honorable Supreme Court, including the case of Ajay Chaudhary.
Ajay Kumar Chaudhary.
Twins, huh?
2015 7 SCC 29.
Para, report instance. The principles laid down in the said case has also been reiterated by, has also, the aforesaid principles laid down in the case of Ajay Chaudhary came up for consideration before a division bench on the aspect as to whether in case of a deemed suspension, comma, the same principles will apply, comma. In the said case of Rakibuddin versus so-and-so, comma, the Honorable Division Bench has held that the same rigors would also be applicable for a case of deemed suspension under Rule 6(2) of the so and so rules of 1964. Full stop. Para. In view of the aforesaid facts and circumstances, comma, the order of suspension dated 5/4/2023 is interfered with. Full stop. The petitioner is accordingly directed to be reinstated in service. Full stop. However, considering the seriousness of the allegations, comma, the respondents will be at liberty to post the petitioner in any non-sensitive post.
And intermediate, but they will complete it.
That is the para, the present order of interference with the order of present direction for interference with the order of suspension shall not cause any prejudice to either of the parties in completion of the disciplinary proceeding in accordance with law.
Obliged.
Writ petition stands disposed of. For
That's number one.
Hazarika, huh? G. Hazarika.
I'm deeply obliged.
Mr. Chutia, we are not very happy in passing
No,
this kind of
correct,
orders,
my lord. I,
but we have to follow the law.
yes, I.
Allegations are serious, you should pass the order, either exonerate or whatever you want to do.
I remind
This
him,
kind
my
of
lord,
default
over
thing,
tele-
we are not very happy. This is a default thing, default benefit.
Yes, over telephone, I talk to them, my lord.
If you think that allegations are serious, prima facie it appears so, you act in accordance with law.
Deeply.
I didn't want to follow the list. Rakibuddin to আছে tomorrow. Rakibuddin আছে division bench. Rakibuddin division hetu code করে দিবে না? Yes.
Lordship, in this case, the petitioner was appointed as section assistant under PWD on 27/1/19.
Public Works Department, Mr. Nath. Public Works, you are appearing in item number 1. Yes, no, old matter. Let him start. Let him start, or you call your colleague, whoever is. Yes, what is the matter?
The matter is regarding the non-consideration for promotion, Lordship. The
Promotion.
petitioner- Promotion, your Lord.
You are a
Actually,
section assistant.
section assistant.
You aspire to become what?
Assistant engineer, Lordship.
Assistant engineer.
Not assistant, Lordship.
You are in the ministerial post. How can you?
Sub-engineer grade 2, your Lordship.
Sub-engineer.
Sub-engineer.
You are a diploma holder. Are you a diploma
No,
holder?
metric holder, your Lord.
Matriculate.
Metric.
You matriculate is eligible to hold the post of sub-engineer.
That is the rule, your Lordship.
No rule. Let us see the rules.
Lordship, unfortunately, we couldn't have the PWD promotion service rule, your Lord.
Then you must be basing your case on certain rules or regulation or norms. What are the norms?
Yes, Lordship, based on the gradation list prepared, your Lordship.
No, there has to be a promotional ladder as per a rule that section assistant is eligible to be considered for promotion to the next post.
Yes,
In absence of rules, we cannot make such a direction.
In it, Lordship, can a matter be after 1 week, Lordship? So we
No,
not
15
prepared.
15 matter. We are not adjourning matters of this kind. Had there been some serious issue? Yes. No, nothing. How do you aspire to become from section assistant to a sub-engineer? You are a matriculate. You are lucky that you are at that point of time matriculate can become a section assistant. Nowadays you cannot. Grade 3, you need to be a graduate.
Also, we are not able to obtain the inspection also in the time, Lordship. When
We'll close
after
this.
after 2 days, we can get proper inspection. And then
No, we'll close this. We'll hear you. We'll consider everything. Let the PWD council come. Wait for a while. All of this up.
It is a lot. Can this matter be taken up at 2 o'clock?
2 o'clock today.
The file is with Mr. Mazumdar, it is not with.
2 o'clock will be uncertain. This court might rise early. There is some personnel issues.
Lordship, next week, then Lord,
15 matter, we're not adjourning. After some time, no problem.
after some time.
Okay. What is the matter about?
Lordship, this is regarding the SPOs, Lordship, who were terminated from their services in 2015. The respondents, they have filed an affidavit in opposition. There they say that they will form another battalion of AISF where they will absorb this SPO.
That has been done.
Yes, yes.
Did you participate or
One
not?
one ASF battalion, existing ASF battalion, the SPOs were engaged. Lord. Thereafter, they brought another notification whereby they said that they will give 2% reservation in every police recruitment, which is also been done.
You get hold of the brief after a while, we'll take this up.
Lordship.
15 matter, no adjournment.
I didn't read. Hello. Sorry, see, it is an old matter, I think, my lord.
Mr.
prepared the-
Mr. Purkasta, we had looked for you and along with Mr. SP Chaudhary.
Yes.
You did not point out a very important provision in that case,
Which one, my lord?
execution,
Oh, yes,
award.
my lord.
We had to, after dictation, we would.
But just come to your lordship notice.
Yes, we had incorporated that, so we wanted to inform you.
Hello.
There are provisions and not recent amendments, 10 years back amendment.
Wow.
It has to be treated as a decree.
What decree?
Now, I asked you to make some
Yes,
research, you show 29. 29
Yes,
is the
29
criminal part. But
other days, my lord, I have
it can be executed as a decree of civil code.
the lordship is supposed,
Section 10, section 11.
section 11. My lord, I am sorry, my lord. I have already apprised your lordship, my lord. I am a little knowledge about this. My lord,
No, I had given you time to look through the act, you did not even look through. Okay,
hello,
tell us, what is this?
lordship is supposed to modify the order.
No, we have done, we have
Ah,
incorporated.
Well, before my schedule starts, my lord, I'm praying for the accommodation for the day.
What is the matter about?
That is regarding discharge.
My lord, I am also, my lord, I prepared the case not up to the satisfaction. of the
Doesn't
court.
matter, we'll finish this off. Why do you need time, Mr. Adhikari?
I'm not well, bro. The last 2 days, my lord, I'm suffering from severe gastritis.
15 matter.
Any other day, but tomorrow,
Tomorrow.
Adhikari.
Monday, lordship, can we pick up the matter Monday? I prepared the case, my lord, but I have to.
Well, what are your grounds?
Ground is then, my lord, whether old ad entry will automatically empower the authority, my lord, to discharge. There are a number of decisions on this point. I will prepare
You have 4 number of red entries.
ad entry.
What is your posting?
Posting is a cook, my lord.
As
Cook
cook.
in Assam Rifle. Therefore, a number of decisions are there. They have cited some decision. Of course, my lord, backdated judgment. Recent judgment, our division bench has, my lord, our division bench.
Red entry for what misconduct?
Misconduct is, my lord, unauthorized absence, number 1. 1, 2, 3, unauthorized absence. 4th one is, my lord, missing of certain documents,
I card.
I-card. And whether it will be construed to be, my lord, misconduct. Because I had lost affair, inquiry or investigation was done. They said, my lord, incident occurred, but we could not trace out the documents.
If you are a cook, we thought that your misconduct would relate to your cooking. You cannot prepare tasty food.
I-
Officers do not like you.
Don't like me. This is the only question, my lord,
What is a cook doing with I-cards?
because I'm a member of the, my lord, of the courts.
But
Therefore, I am
I-cards are missing. Why
affair,
I-cards?
affair was lost when I was on the
And
way
why
to,
unauthorized leave? How many days?
my lord, 2 days, 3 days, one is 52 days, and they impose already penalty,
52 days.
52 days. And they
52,
impose penalty.
52 days, your unit will go without food.
No, that part is over. Because they already, my lord.
How many people have died in 52 days without food?
I-
Cook is not there. How
They have
how
their,
they eat?
they have their alternative, I think, my lord.
Swiggy,
Ah,
Zomato,
Senior cook, junior cook, assistant
Okay.
cook.
not Swiggy, Zomato.
Ah.
Which place?
About, my lord, I was discharged from service while I was working in Aflong,
Sontila,
only.
Sotila.
Lokhara, I think, Lokhara. Lokhara.
Okay, when?
Monday,
Next Tuesday, my lord.
Next Tuesday.
fixed matter.
Next Tuesday, we have got matters, I think. Heard Sri AK forecast. No, there is a joint request from the made by the learned council for the parties for a short accommodation.
Next,
Full stop. Considering that this matter is of the year 2015, comma.
next,
15, common as an exceptional case, a short accommodation is granted, directing listing of this matter on the
20th,
21, not 20,
20,
20.
Tuesday,
I'm obliged, madam.
Tuesday.
all right.
Sir, I'm really sorry, madam, I could not assist your lordship with that action, madam.
See section
Yeah.
11.
Oh my God,
Value incorporation.
I-
Sir, have you seen the order of this court?
no, earlier order I have obtained.
No, this final order.
Final order I will obtain, madam.
Please obtain.
I-
Mr. SP Chaudhary,
Yes, I will.
no assistance.
Okay, all right. 45.
Jud board,
Good corporation.
Jud corporation. How do you execute an award of the tribunal?
By way, it is a decree, my lord is saying it is a decree in terms of section 11.
It had to be a decree. We asked you to show the provision. While passing the judgment, we again saw the provision. We knew that there was some provision. We had incorporated. That's why we tried to locate both of you.
My lord,
You were not traceable.
I'm sorry, my
Because we
lord.
wanted to explain.
Yeah.
It's not making any difference to the final order.
Fine.
Because we had only said that writ court is not the executing court. You have to take recourse of the law.
Recourse.
He had only pointed out 29. It's a complaint, but under section 11,
It is
you
a
can
decree.
straight away go for an
Hello.
execution.
I'm sorry for the lapse, my lord. Obliged paper.
You try to take out a copy. It's been
I'll-
made online that day itself.
Already I've intimated them, then I will re-intimate them.
Okay, next.
Obliged.
In item number 1,
PWD.
PW, look, I did not find the file. Look, the
Who's been entrusted?
second, look, my colleague is on the way. But
Okay.
the petition copy is not with us. It's a old matter, look, the second copy, if
No,
I,
there's nothing in this matter. You take the second copy.
if I get the second.
Yes.
copy.
Take the second copy. Item number 1.
After
Huh?
sunset, look,
খুলে দিব দিয়ে, কি হবে?
after sunset, look, I'll,
Yes. খুলে দিব দিয়ে, হেৰি। পুৰণা ফাইলিং না আগতে একেলগে ফাইল কৰি দিছিলে।
Please, your lordship. PS locker is on another port, your lordship. He is on legs. Kindly fix this matter at your.
You are both on the same side or why? What?
No, your lordship, but he told me that.
On behalf of case property.
No, your names are together.
No, that's
No, your
Because
lordship,
this-
I am for the petition.
She's also for the petitioner.
it's not.
You're trying to confuse the court.
No, your.
It is any talented.
Huh?
Any talented.
You're not
Either.
any talukdar.
What?
But here it's written eight
I am-
talukdar.
I am appearing for the petitioner,
who-
Pidas, your lordship.
Union of India, who's there?
PS
Please.
locker.
He is on legs, lordship.
Okay, after a while, what is the matter?
But your lordship, here, your lordship, I am challenging the unsatisfactory in TRT, your lordship, challenging the impugn order that discharge from his service, your lordship. Petitioner has discharged from his service.
What were you doing?
Your lordship.
Plumber.
Liquid plumber, your lordship.
Okay. We had taken up someday, 2 months back, this matter. Plumber case.
Yes, your lordship.
Long.
Long.
Okay. After some time.
Keep your place.
May I please, Lord? What Deliberation can see now in court number 1 month.
Hmm?
After some time, man. Court number 1 month.
Who?
Can to the
Mr. Mohanta for whom? APSC?
No, my lord, it is Congress case.
Gaura,
Gaubura.
Only small point, my lord, he is not.
You want to be a Gaubura?
my lord. Yes,
You are a king.
my lord.
You are a king. What is your name?
Raza Ali, Raza.
Why
Raza.
does a king want to be a Gaubura?
That to him, village. is not-
Degradation.
My lord.
Degrade. From king to Gaubura.
Gaura.
You remain a king. Don't bother. But we are joining matters. We cannot do like this. Ask him to come after a while. What is the issue, Mr. Mahanto?
Issue, my lord, only confined to only one. He is not, he is, my lord, not the person from that village. That is the one of the criteria.
At that time, point of time, was this criteria available?
My lord, available.
It was not in the advertisement mail.
Yes,
Rule-
correct,
It was
absolutely,
not there.
yes, absolutely correct. It is not
Rules,
there.
rules,
My lord,
rules.
yes. Rules also, there is a direction from this honorable court.
Okay,
There is a direction, but
okay,
it is,
okay,
although it is not in the advertisement.
okay.
So that is, they admitted, my lord, they is not in local, that is the only point. Since he is not eligible for the appointment as a Gampura in that village, my lord, other things are, my lord, not going to
Okay.
happen. That is the case.
You are for the private respondent.
I am the, yes, private was selected, my lord. Problem is that he is enjoying. He is now enjoying the Gampura.
Okay, who's for the state? Madam, you are for the state. We'll like to have your response also.
Already affidavit,
Okay, after a while.
in the affidavit clearly mentioned that, my lord, he is not the person from that.
Okay.
Item 7.
Wait, Vijay. This is regarding an issue of promotion from handling labor to Mondal in FCI. Now, the issue that is pertinent to be adjudicated here is, now what has happened here? Now, there are various depots. FCI has got various depots. In
Mr. Roy, you have filed affidavit.
affidavit has been filed, replies also been.
Readings have complete.
We can have this for disposal.
Yeah.
24 matter will give preference to all matters. 24 matter.
Only thing is that I'm not protected and there's a promotion that is completely against their own guidelines. So the philosophy will fix a date for disposal. Otherwise, the issue is very simple. They are meant.
Mr. Sharma, we don't mind taking up matters, but there are all matters.
I understand, Lord. I understand. I
15
will.
matters, 16 matters.
Only thing is that regarding that consideration for interim, that option.
Is there any
Because
is there
promotions
any
have already taken place.
no, is there an observation made that you can renew the prayer for interim?
Because there,
It's not that, my lord. Promotion has been taken place now already. That's how the promoted person have already joined their work. So lordship may hear any day, but finally, lordship.
But we will not go for a rule. We'll have it at
No, no,
a admission
no,
stage.
no,
because,
Admission stage will have.
because if
Okay.
philosophy will see, it's a clear-cut case of violation of their own rules. Their own rules pertains to separate lists, wherein
Okay,
for these
okay,
particular
okay,
incumbents,
okay.
they have not done that.
The pleadings are complete. And it is the joint prayer made by the learned counsel for the parties that the matter can be disposed of at the admission stage itself.
Yes,
Full stop. Considering the aforesaid submissions, comma, list this case for admission hearing, not immediately. We'll have a date,
After 10 days, my lord.
not 10 days. On the 10th of September,
Lord.
10th September.
Obliged, Lord.
It's a Tuesday. Well,
Lord.
Yes, Lord. Obliged.
Yes, yesterday's matter. Yesterday's matter. Yes. Somebody had taken time yesterday. Help.
Yesterday, for Mr. Gogoi, it was P. Gogoi.
Mr. Bora, please call Mr. Gogol. You will appear. Very good. Okay.
But this petitioner, they had a postgraduate teachers of homeopathic colleges.
How many of you are there?
13 numbers of petitioners are here.
Some had passed away. Yes,
My lord, one has passed away.
Just a minute. I think.
He is being substituted.
Just a minute. 10 retired.
10 retired.
Okay, just a minute. 13 petitioners, 10 retired.
During pendency, 10 retired.
One died. One died. The person who had died, he has been substituted.
Substituted.
But the cause of action is still there for all.
Still there.
For all.
For all.
As you are serving as?
Postgraduate teacher, yes, assistant professor, associate professor. Now they are professor.
Postgraduate teacher.
Postgraduate.
Where?
In the homeopathic medical colleges, earlier 3 colleges were there. Now it is amalgamated into 1. Earlier there were 3 colleges. Guwahati, Nagaon, and Jorhat. Now in Guwahati, all are amalgamated.
Yes.
At the time of initial joining, my lord, they were diploma holder. And at that time, these colleges were imparting diploma education. And subsequently from 96, 97, the bachelor degree courses are being provided. And
from 96, 97?
96, 97. And the Central Council of Homeopathy by notification 13/3/1990 is diploma.
1993 you have said the degree course.
1996, 97 degree courses started.
96.
96, 97.
Degree started.
Degree started.
Okay.
And prior to that, by notification dated 13/3/1990, the Central Council of Homeopathy by notification dated 13/3/1990, this diploma course has been equated to degree course. That is at page 30. And pursuant to this notification, Government of India has declared this 4.5 years, this diploma course equivalent to degree course, PHMA.
Which by notification?
Notification, Central Council of Homeo notification
That is 13/3.
13/3.
And
Subsequent to that, Lordship will get at page 31.
this is by?
This is 3rd January 1991.
By whom?
By my lord, Government of India, Ministry of Health and
Okay.
Welfare.
And
Direct-
after Central Council, the ministry had
Yes,
passed the subsequent.
Ministry has passed the order, my lord.
Government of India
Government of India.
had approved this,
Approved
had
it. Yes,
accepted this,
accepted it and it was made equate.
accepted council's recommendation.
Yes,
Hmm.
CCS recommended. Subsequent to that, my lord, in 2001, there is an amendment in the Central Council of Homeopathy Act 1973. By that amendment, the in-service diploma holder teachers, they were allowed to pursue their postgraduate course. Amendment of 2001, that is Homeopathy Central Council Act 1973 was amended, and in-service candidates were
In-service diploma holder.
in-service diploma holder teachers. They were allowed to pursue their MD.
Pursue their masters.
Master.
Yes.
And
There.
accordingly, these petitioners, they completed their masters. There was earlier round of litigation in 2000. They prayed for AICT pay scale, but in that order, this honorable court directed the government to take a decision. But
That was in 2000.
2000, my lord. But government said no, they are not entitled. That was the government's step. My lord, in 6 pay commission,
Hmm.
My lord, the postgraduate homeopathic research association, they submitted memorandum before the 6 pay commission for providing them the AICT pay scale.
Hmm.
And pay commission report, which you will get it at page 48. Pay commission asked the government, it starts from page 48.
Hmm.
And where 6 pay commission has provided equal pay scale to the allopathic MBBS doctors, homeopathy, and Ayurveda. That was provided. Same pay scale. But my lord, regarding this research, what pay commission's recommendation is that regarding AICT pay scale for teachers of state homeopathic college, it is for the government to take a decision in the matter. Pay commission did not make any clear recommendation. And subsequently, this association, Postgraduate Homeopathic Research Association, they made representation before the pay anomaly committee.
No, the pay commission recommended the same pay scale for doctors of the three segments, allopathic, homeopathic, and
allopathy,
Ayurvedic.
and Ayurvedic.
But so
But
far
not
as
teachers. AICT pay scale was not provided to teachers.
then what was
The pay commission asked the government to take a decision in this regard. It is at page 51. Then, my lord, this association, Postgraduate Research Association of Homeopathic Colleges, made representation before the pay anomaly committee, it is at page 52. And pay anomaly committee's report is there at page 55. Pay anomaly committee has made recommendation that they are entitled to have, but ask the government to take a decision. Taking all the facts into consideration, pay anomaly committee has stated that they recommended that they are entitled, as they are imparting same education, but providing specific recommendation, government was asked to take a decision. But government is not taking any decision in this regard. They have made several representations before the Health and Family Welfare Department, and Health and Family Welfare Department, in filing their affidavit, they have accepted the claim of the petition. And Health and Family Welfare Department's stand is that they have accepted it, they have recommended it, but Finance Department is not approving it. That is the stand of Health Department in their affidavit. And Finance affidavit, what it speaks, my lord, that Health Department is not making any specific recommendation. It is not clarified. That's why they are not agreeable to that. But in our reply, what we have got through Right to Information Act provision, my lord, we have annexed those note sheets where Health Department has specifically made the proposal that they are imparting same education, having same qualification, and they are entitled. But Finance Department is not approving. That is the hurdle now. If Lordship will have a look into the affidavit filed by the Health and Family Welfare Department,
that is your case.
that is my case.
Okay.
And the doctors of all these segments, they are getting equal pay scale. And while my lord, equating this diploma with degree course, then CCH as well as government has notified that there should not be any discrepancy in pay scale. That is also specifically mentioned.
Now you want your pay scale as per AICT.
AICT. And now, my lord, Ayurvedic is also provided. Dental, nursing, pharmacy colleges, they are provided with that pay scale. Only we are not.
Doctors.
Teachers. Ayurvedic teachers, under same Ayush department, my lord. Ayurvedic colleges, teachers of Ayurvedic colleges, they are getting higher pay scale than us. But we are not. Only we are left behind from the benefit of that. And health department in the note sheet what we have got through Right to Information Act, that note sheet specifically speak in various communication that we are entitled. But for some reason, that reply affidavit to the respondent number 1, my lord,
Page.
this note sheet starts from page 6 of that
Page,
affidavit.
your page. Running page, affidavit.
Page, my lord, that annexure, only one annexure is there. The reply, one reply is there. Against health, there is no reply. Two affidavits are there. Last.
Your affidavit is by whom?
Affidavit reply against the affidavit of respondent number 2.
No, who's the deponent?
Deponent Yamnam Sorita, Dr. Yamnam Sorita.
Okay. Yes.
From page 6 onwards, this is the note sheet. In page 6, Lordship, paragraph 3. Married.
Just a minute, please. 96.
Page 6, paragraph 3.
101. Yes.
Finance Department under point number 1, India so at so wanted to know whether the homeopathic colleges can be equated with the allopathic medical colleges in terms of qualification, responsibility, duty hours, etc. DME Assam, in his views, has shown various grounds stating that homeopathic colleges cannot be equated with the medical college and hospital. As a matter of fact, that facilities for the indoor patients and outdoor OPD facilities, emergency services, pathological investigation facilities, OT facilities, if provided adequately to the faculties of the homeopathic college and hospital, can be fully utilized by the homeopathic faculties by virtue of their capability due to their qualification and knowledge possessed by them. Absence of all these facilities in adequate numbers, quantity, their adequate knowledge and skills are not fully utilized. Now, therefore, it will be unfair to say that their healthcare services rendered cannot be said to be equated with that of medical college and hospitals. Relevant to mention that 3 homeopathic colleges and hospitals are at present equipped with skeleton pathological investigation facilities, including X-ray machine, along with 25 beds and OPD facilities. These facilities could not be increased for want of infrastructure as well as shortage of manpower. In my opinion, quality of service of the faculties of homeopathic medical colleges cannot therefore be undermined with that of the allopathic doctor. Now, my lord, page 7, next page, second part of paragraph 8, the concluding paragraph, my lord. Since all the faculties of Regional Dental College, Regional College of Nursing, Government Ayurvedic College, and Institute of Pharmacy, apart from the medical colleges in the state, have already been extended benefit of AICTE pay scale, including the revised one, hence, faculties of homeopathic colleges also deserve to be considered to avail the benefit of AICTE pay scale, with retrospective effect like the other government healthcare service institutions on grounds as furnished above. It is accordingly submitted for approval to move Finance Department for their kind consideration for extension of benefit of AICTE pay scale, including the revised one, to the faculties of 3 homeopathic medical colleges in the state. Now, my lord, it's 12 of this annexure, my lord. The Health and Family Welfare Department has replied to some query of the finance that how much degree, what is the course provided, the qualification, etc. Page 12 of the Lord. Some queries were made. As regards point number 1, the duration of degree courses provided by the 3 homeopathic medical colleges are 5.5 years, included compulsory rotatory internship. Point number 2, the degree courses in the 3 homeopathic medical colleges was started as follows. Is that a death note? Point number 3, the duration of course in 5.5 years. However, for those who have diploma of 4 years duration are recognized as equivalent to degree by notification number such and such. You are requested to take necessary steps for consideration of proposal regarding AICTE pay scale to the faculty members of Government Homeopathic Medical College. And Finance Department made some query whether some other states are providing this scale to the homeopathic colleges or not. Regarding that, Lord, next page 13. Ayush Deputy Director has made communication. Your endorsements, such as number 1, yes, as per information received by this department, one state is extended benefit of AICTE pay scales to the teaching faculties of Government Homeopathic Medical Colleges. The state of Karnataka is extending AICTE pay scales with effect from 1/1/99 by government order number such and such, dated such and such, to the teaching faculties of Ayurveda, Unani, and homeopathic colleges under Indian System of Medicine and Homeopathy, presently known as Ayush, by notification dated. All the teachers in homeopathic medical colleges are allowed to draw AICTE pay scale who are possessing PG degree, etc. Teachers having diploma in homeopathy recognized, CCH and equivalent to degree are given AICTE pay scale. Degree, diploma, or PG degree of the teachers of all 3 homeopathic colleges of Assam are recognized by CCH. This is the communication. Now page 15, my lord. Page 15, the second one, Health and Family Welfare Department's communication. This last number 5, Finance Department asked whether Finance Department agreed for equalizing the pay scale of medical officer homeopathic who are having diploma qualification and PG qualification with that of medical officer in other system of modern medicine. What was Finance Department decision? Not at page 24, the Health and Family Welfare again made a communication. Page 24, reference such and such, justification furnished by the Director of Ayush, Assam at page such and such. The Health and Family Welfare Department agrees with the views of the Director of Ayush. You are requested to approve the proposal for providing AICTE pay scale to the faculties of homeopathic medical colleges, Assam, as per CCH and as per report of the Anomaly Committee 2010. The faculties not having PG degree in homeopathy should also be allowed to AICTE pay. So the Finance Department stand that health is not providing specific recommendation. That so far I understood it is not correct, because Health Department has made specifically that they are entitled.
Okay.
That is. Now, my lord, I'd like to refer the affidavit of health. Lord. Health Department's affidavit. It is sworn by Subrata Roy Burton. Affidavit by respondent number 1.
Yes.
But page 2, paragraph 5. that as regards the statements made in paragraph 3 of the petition, the deponent begs to admit that AICTE pay scales are granted to the faculties of nursing, dental colleges along with
You're
pharmacy.
reading which paragraph?
Paragraph 5 of page 2, Millard.
Yes.
That as regards the statements made in paragraph 3 of the petition, the deponent begs to admit that AICTE pay scales are granted to the faculties of nursing and dental colleges along with pharmacy institutes in addition to faculties of medical colleges and government Ayurvedic college. The Health and Family Welfare Department had submitted proposal to the Finance Department for granting AICTE pay scales to the faculties of homeopathic medical colleges of Assam, particularly those who obtained postgraduate qualification in homeopathy. Next, paragraph 8, Millard. That regarding this diploma and degree are made equated. Paragraph 8 says regarding that.
Hmm.
Now,
No, that is not the
that is not the issue.
that is not the issue.
That is not the issue.
There is no controversy regarding your holding the qualification.
Yes.
You're only on the issue regarding the pay scale under the AICTE.
Yes.
And you have shown, you are trying to show that the administrative department has been recommending.
Yes.
And finance departments, therefore you submit that the stand of the finance department, there is no specific recommendation. That doesn't appear to be correct.
Yes.
That is your case.
That is it. In paragraph 13 of this affidavit, page 3, Millard, that as regards to the statements made in paragraph 14 to 20 of the writ petition, the deponent begs to state that the matter of implementation of pay anomaly committee 2010 for granting AICTE pay scale to the faculties having postgraduate qualifications in homeopathy is being earnestly followed by the Health and Family Welfare Department. The department requested the Finance Department to accord approval concurrent for granting AICTE pay scale to the faculties of homeopathic medical colleges of Assam, particularly those who obtained postgraduate qualification in homeopathy. The file has been returned from Finance Department seeking certain clarification. As such, the file is under process in Health and Family Welfare Department. This is the stand of Health Department. Now, in this regard,
let us see the stand of the finance department.
Finance Department stand. It is a very filed by respondent number 2, squared by Manmohan Das, on Mr. Manmohan Das. It was filed on 15/3/2016.
Just a minute, please.
Much.
Yes.
In this affidavit, page 4, paragraph 10, that you may kindly have a look at. Paragraph 10 at page 4. That as regards to the statements made in paragraph 14 of the petition, the deponent most humbly begs to state that a proposal for grant of AICTE pay scale to the homeopathic research and medical colleges was received in Finance Department from Health and Family Welfare Department. The proposal was simply sent to Finance Department without due examination by Health and Family Welfare Department. The matter was examined in Finance Department and some information in the matter was sought from Health and Family Welfare Department. But so far, no reply has been received from the Health and Family Welfare Department as yet. Health and Family Welfare Department was requested to submit specific views and comments on the proposal being the Administrative Department with justification for granting pay scale of AICTE to the faculty members of homeopathic colleges, Assam. Without specific information from the Health and Family Welfare Department, it is difficult to agree to the proposal since AICTE pay scale is recommended by the central government. This is a stand of finance, Millard.
That this is basically your case.
This is basically my case, my lord. That others are getting under same IOS department, Ayurvedic colleges, faculties are getting.
Perhaps you will not have much to say, Mr. Bora. But if Mr. Nayak is raising some, not exactly, he is not opposing. He is seeking, he means the finance department is seeking certain further clarification from you.
Yes, my lord.
Mr. Haloi says that there may not be requirement of further justification or clarification. It is done in a number of note sheets if he has annexed. But whatever the further clarification they need, you give them, and there otherwise there doesn't appear that there is some serious dispute with their claim. Regarding the qualification, there is no issues at all.
But my lord, because they are basically claiming pay parity on the basis of the qualification and qualification, my lord. But my lord,
No, in your affidavit, you have already given you have made your stand very clear. There is no objection from your part.
yes, my lord. But my lord, as per the guidelines or the principle laid by the done by the Supreme Court, my lord, wherein the Supreme Court has decided in various cases that, my lord, for the principle of pay parity can be considered if there is complete and wholesale identity between the two groups, my lord.
That perhaps will not lie on from you because you have already recommended.
We have recommended, but there are certain observation or clarification sought for by the finance department, my lord.
You have not stated those things in the affidavit.
Yes, my lord.
You have rather what Mr. Haloi has pointed out, those paragraphs, in more than clear terms, you have said that yes, we have clarified. And he has also annexed the note sheets, which shows that you have applied your mind. So far as the qualification is concerned, no issues at all. You are going to Ayurvedic colleges, allopathic obviously yes, and they are homeopathic teachers.
But on the basis of the qualification, they are claiming pay parity on the basis of the qualification only, my lord. But on the basis of qualification only, my lord.
Not only qualification, the nature of duties performed.
Nature of duty also, my lord, that has to be determined by an expert committee because, my lord, the nature of duty or.
No, Mr. Bora, if you oppose this writ petition, you have to oppose in the affidavit. Show us the affidavit in the portion there where you are opposing the petition.
Yes, my lord, I know.
You are not opposing. Rather, your stand is in favor of the petitioner, and matter has almost reached a verge of completion. There is some clarification which has been asked for by the finance department from you. And that is if something else is shown by Mr. Nayak, we do not know. Mr. Haloi has very categorically led us to the affidavit in opposition dated 15/3/2016 of the finance department, that though proposal was received, there was no justification. We asked for justification.
Yes, my lord. Because that is the justification, because the nature of duty, my lord.
Where is you stated that there is no justification? You have not stated. Why are they aggrieved? They are not aggrieved by your inaction.
Yes, my lord.
They are aggrieved that finally the matter has not reached a finality. In spite of there being recommendations by the finance department and consideration by the finance department, it has not reached finality. You have been giving to the Ayurvedic doctors. I mean the teaching staff.
Teaching.
Doctors are, we are not the.
Doctors all are getting equal.
But my lord, on that basis, they cannot claim that we have given to Ayurvedic doctors or allopathic doctors. On that basis, they cannot claim, my lord.
No, not on doctors. They are not doctors. They are teaching.
Teaching, sir, my lord. On
Teaching.
that basis, because only because the nature of duty or identity of the duty and wholesale duty, my lord, wholesale identity has to be determined by a expert committee, my lord. Because
Mr. Bora will not allow you to argue that if you do not state it in your affidavit, your argument will be contrary to your affidavit. If you oppose, you have all the liberty to oppose. But your opposition has to be, or whatever stand you take has to be consistent with your stand in the affidavit.
yes, my lord.
If you had not filed affidavit making a submission on law, we would have accepted. Now affidavit says something else. In fact, there is no opposition either by you, even by Mr. Nayak. Nayak says that Utshe, perhaps that we sought for clarification, they are not giving.
But my lord,
And you are the department, administrative department, who have to justify and give it to finance.
and my lord, subsequent to filing of the affidavit, my lord, affidavit was filed on, my lord.
Your affidavit,
Yes, my lord.
your affidavit, we have the date. Your affidavit is 26/2/18.
Yes, my lord. Subsequent to filing of the affidavit, my lord, there is a judgment by the Supreme Court, Honorable Supreme Court, wherein, my lord, the Ayurvedic doctors, my lord, they also claim for pay parity, my lord. Then, my lord, ultimately on this principle that, my lord, there has to be identity and wholesale identity, my lord, between the functions and the qualifications, my lord.
But here, that
It
in
is a
spite of,
subsequent judgment, my lord.
no, in spite of there being a judgment, so far doctors are concerned, though it is not the issue before us,
The issue is the wholesale identity between the two groups, my lord.
Mr. Bora. We are not on the judgment, but irrespective of the judgment,
Yes,
so far doctors are concerned, you are giving equal pay.
no, my lord.
You are not giving equal
No,
pay.
my lord. They have been denied, my lord. In this case, the Ayurvedic doctors, my lord, the Supreme Court, wherein the
No, you are in Guwahati, in Assam.
yes, my lord. No,
You are not giving equal
my
pay.
lord. No, my
Ayurvedic doctors?
no, my lord.
Where have you stated?
But Ayurvedic doctors, actually, my lord, there is a writ appeal also pending before the division bench, my lord. Saying they are also praying for the pay parity, my lord. Ayurvedic doctors.
But when an expert body like the Pay Commission at page 48
Yes.
has recommended pay scale, same pay scale for doctors of allopathic, homeopathic, and Ayurvedic,
That is, my lord, recommendation, my lord.
that is recommendation
Yes.
by an expert committee.
Yes.
If you have the prerogative of not to accept the recommendation,
Yes,
but
my lord.
expert body has said that they are entitled. But the recommendation unfortunately was not given directly for the teachers.
Subsequent to this recommendation, my lord, the judgment of the Supreme Court.
Now, what is the, are you paying the same? You're not paying the same to
No,
doctors?
my lord.
No, they are
And
paying.
in this case, my lord, Supreme Court, the Ayurvedic doctors were there before the Supreme Court.
No, that were from the
Right.
state of Assam.
No, my lord, it is from the state of
No.
Gujarat,
So
my
far
lord.
as state of Assam is concerned, can you get the instructions that you are paying less than the AICTE? From where are you making this submission? Do you have instructions?
Because there is a writ appeal pending before the division bench, wherein the Ayurvedic Doctor Service Association, they have filed a writ petition and subsequently they have approached the division bench.
Writ petition for?
Pay parity, my lord. Along with at par with the allopathic doctors, my lord.
Even the doctors of Ayurvedic are not getting the same pay.
No, my lord, they are getting same pay. So for my instruction is concerned, my lord,
No, he
they are
says
getting
that
same pay and my lord,
Huh?
in the note sheet also, in note sheet also, it is clear that Ayurvedic,
My lord, I will
homeo,
get the
allopathic, all
No, let him
doctors are
get the instruction. He is representing the department.
Yes, my lord.
Mr. Bora, whatever he says, we will normally accept.
Well-
And he is also referring to two court cases. If they are getting the same pay, why should they approach the court? Number one, writ appeal is there. You also try to get hold of the writ appeal writ petition in the online, you'll get the order. You come back to us after some time on this issue.
Yes, after 15 minutes.
But yes, but your statements in your affidavit are very clear. After that, the judgment has come, and if you're not giving equal pay to doctors, there might have some relevance in our decision-making process. Mr. Nayak, what do you say?
There also one round of lordship if lordship comes to page 34 of this certificate.
30?
4. And ordered it at 13/10/2013.
Just a minute, please.
that I have referred also. That 2000 litigation.
So it was handed back to the authority to decide the
These were for the doctors.
issue is same lot, pay parity. Some are research, some are doctor. So thereafter, lordship, it was placed before the committee, lordship.
After the remand, what happened?
So thereafter, the process started. In fixed pay commission matter was placed before the committee. Committee made certain recommendations. And thereafter, a proposal was furnished to the finance department. But finance department sought for some additional clarification. And so far as this affidavit, this was filed in the year 2016 itself, Lord.
Yes.
So not
Those additional queries have not been met by the health department.
at least in this affidavit, Lord, that is the fact from
No, thereafter, your affidavit is of 2019.
16.
16, thereafter, health department has not clarified.
Till the date of filing this affidavit, nothing was clarified. So if
Mr. Bora, what the instructions?
No, my lord. My lord, can it be on tomorrow or Friday, my lord? Because it will take some time because the concerned person I called up, my lord, he is not in a position.
No, you can get hold of the online copy of the single judge's order. That will be very easy. We can have it after some time.
Can it?
Tomorrow,
Or Friday, my lord.
what
tomorrow.
if I would also like to request your lord to grant us some time? What if I have gone through the affidavit and affidavit of 2016? Thereafter, probably some more facts may come out.
But
What
if,
you-
no, if, see the matter, whatever was stated in the affidavit and the exchange of pleadings would give an idea that there was no serious opposition to their claim. Clarifications were sought for between the
At
departments.
least a proposal was there without any justification. That is my.
That is your stand.
That is the
that
stand
is-
of the finance
And
department.
notice by Mr. Haloi, which has been annexed,
Not-
that shows that a recommendation proposal was done by some application of mind. Your
Okay.
employees will get a better pay scale. They're working. What is?
And I would also like to submit when Lordship will pass any order in this matter, Lordship will also take note of the law settled by the Supreme Court in this regard. Now the settled law is even if they are holding the same post, same post, same.
No, Mr. Nayak, your submissions would be relevant if you are opposing in principle. There is no opposition in principle. And the stand in the affidavit is something else. You have almost abided by the recommendation of the pay commission. You sought from clarification from health department. If the health department gives the clarification, matter ends there.
Yes, I agree, but only.
See,
submission is-
these are matters which an expert body has
Yeah.
applied its mind, recommended. You could have said that, no, we are not accepting the recommendation.
Because that stage has not yet reached.
But the health department says that, yes, we are accepting and we're proposing to the finance department. Finance says that we need to give further clarification. The matter is at the stage.
That is the issue.
If it was at the basic stage of whether you are entitled to equal pay, then you are entitled to make all the
That has
submissions.
not yet been decided.
That has come.
That is clear.
When? Day after tomorrow, Friday? Or tomorrow? These are old matters.
Same
Better, my lord, Friday.
on number of occasion case was listed, the instruction was
My lord.
sought.
Now it has,
No, we have heard this matter. We'll finish this off. Right. And earlier round also remanded the matter to the government.
Exactly.
Government has taken a decision. We have to see the history. It's not for the first time. Okay, we'll have it on Friday.
Friday.
16.
16. Full stop. Heard Sri K. M. Haloi, Learned Counsel for the petition as full stop. Also heard Sri D.P. Bora, Learned Standing Counsel, Health and Family Welfare Department, and Sri P. Nayak, Learned Standing Counsel, Finance Department. Full stop para. After hearing at some length, comma, both the Learned Counsel for the departments pray for some time to enable obtaining of the instructions regarding the instructions if there is any further development in the matter. Full stop para.
Got it.
List on considering the matter to be of the year 2015, comma, list on Friday.
Lordship may pray for listing this matter on 28th. Some time I will get thought. Otherwise, 15th is also holiday. On 20th or Tuesday.
Tuesday. Okay, Tuesday.
Tuesday.
As
What?
part had matter.
We have said we have heard at length. We are not saying anything. We're not looking any matter parted.
apply.
Huh?
20.
2-0. 2-0. Admission এটা আছে নেকি আৰু এটা কিবা আছে নেকি দুটা আছে এটা টপ অফ দ্য লিষ্ট আছে ন টপ অফ দ্য লিষ্ট এটা আছে নহয় টপ অফ দ্য লিষ্ট কি হ'ল আহিছে না PWD item 1 yes the পুরনো মেথড টপ অফ দ্য লিষ্ট 15 এক পড়ি মেথড
Lordship, humbly request one week time to prepare because we're not able to find the rule book actually, Your Lordship. Without it,
Mr. Nath will help you if there's any rule book. Don't worry. You place the facts.
Lordship, the petitioner was appointed as a section assistant.
Sorry, what is your name?
Loken Soikia.
Your name?
J. Das.
J. Das. Mr. Nath will be appearing for PWD?
Yes.
Yes, what has happened? You are what?
Section assistant, Your Lordship. And I joined duty on 27/1/1969, Your Lordship.
27/1/1969?
Yes, Your Lordship. And actually, I reached the age of superannuation on 31/7/2009, Your Lordship.
You joined section assistant as, or you joined as some
Direct-
other post?
No, directly as section assistant.
In the PWD?
Yes, in PWD, Your Lordship.
Then you retired when?
31/7/2009, Your Lordship.
31/7/2009?
Yes.
You
After-
came to the in 15 or what? Retired.
Lordship.
Then
Then what?
you filed this case in 15.
Yes, Your Lordship. Case was filed. But unfortunately, during that pendency of the writ petition, I reached the age of superannuation.
No, you had
We
no,
don't-
you said that you retired in 2009.
Yes.
9 or 19?
No, 2009, Your Lordship. This case was filed in 2015.
15.
Prior to that, there's another writ petition.
You had filed another writ petition
petition.
earlier during the tenancy of your service.
When I was not considered for the promotion,
What is the date? What is the writ petition?
writ petition number is 3049/2009.
304 of 2009.
3049.
3049 of 2009.
9. And in that case, Your Lordship, because I reached the age of superannuation, I withdrew that writ petition with the liberty to approach this honorable court again. And in Annexure T3, the order is given to you.
Page?
17.
Is it 17?
17, Your Lordship.
What was the liberty?
To approach the authority concerned by filing appropriate representation, agitating the grievance of the petitioner, Lordship.
Not liberty not to approach the court, liberty to approach the authority.
Yes, sir.
You would file representation.
Yeah, I filed representation. Annexure number 4, Your Lordship. Next page. Page 18.
Page
18.
18. One eight. Yes. What is the date?
The date is not specified in the text.
Okay, please read. Yes. Please read.
Sir, with due respect, I beg to state that I joined this department on 27/1/1969 as a section assistant. However, in my whole service career, I was never promoted in spite of my due qualification, seniority, and experience, etc. On 27/1/2005, a draft seniority list of section assistant was prepared by Your Honor, wherein my name appeared as serial number 16 for the purpose of promotion to the post of sub-engineer grade 2. A few junior incumbents were promoted from the state list, depriving me from such promotional benefits. In this connection, I filed WPC number 3049 of 2009
before the Honorable High Court, but in the meantime, I retired from service on 31/7/2009. Under the circumstances, having permission from the Honorable High Court, I beg to submit this representation for your kind consideration in favor of my promotion from the date of preparing the state seniority list or the day from which other similarly situated candidates, incumbents of the state list were promoted. It is therefore most respectfully prayed that your honor would be graciously pleased to pass appropriate order granting me promotional benefit as sub-engineer grade 2 with effect from 27/1/2005, that is the day on which list of incumbents, including the undersigned, was prepared, or from the date on which the incumbent of the state list were promoted to the post of sub-engineer grade 2 for the interest of service. And for the act of kindness, I shall remain ever thankful to you. This was
Okay.
address to Chief Engineer, Public Works Department, Assam.
Okay.
And then also there's a reply to this representation that is in annexure number 5, next page number 19, your lordship. A reply by Additional Chief Engineer Planning, PW Road, Assam, Guwahati, your lordship.
Yes.
Your lordship, and I'll read out the reply. Your letter number NIL dated NIL and order dated DOC 1/2011 passed by the Honorable High Court in WPC now number 3049 of 2009. With reference to above, this is to inform you that as per record, it appears that no promotion order for promotion of untrained SA issued for last 5 years as claimed by you, and there is no provision for your promotion as you have already been retired from service on 31/7/2009. This is for your information. So against this impugned reply, we have filed this present petition, lordship.
This is the impugned communication.
Yes, the lordship.
Okay.
First, I'd like to bring attention to annexure number 2, your lordship, page number 12. In that, we given the type copy also.
Regarding?
Regarding the draft seniority list for promotion of untrained regular SA to the post of sub-engineer grade 2. This is in this letter was issued in 27 January 2005. Please find enclosed herein one set of draft seniority lists showing probable seniority position of untrained regular section assistants. The seniority has been fixed in the basis of date of joining as SA and taking into consideration the date of birth in case of similarly situated case as per record available in this office. Before publishing the final seniority list, it is felt necessary to finally verify the date of joining, date of birth where necessary with the authenticated records of division. You are therefore requested to verify the information appeared in the list in respect of incumbents working under you and intimate correct position as well as missing information for which following points may be please be taken into account. So this is list has been issued by Chief Engineer PWD, your lordship.
Okay.
And in that my name is appearing in serial number 16.
16, yes.
Your lordship. So and that at that point of time I was eligible also for the promotion, lordship. So I already completed more than 25 years of service. Even then the promotion I have to withheld from the promotion, lordship.
Now, what is the qualification required for being considered for promotion to the post of sub-engineer grade 2? You are matriculate.
Yes, Lord.
Because gradation list you have, it clearly states that you are matriculate.
Yes.
Where are you having the qualification?
Lordship, that's what that has to be like that.
Okay, we'll get the feedback from Mr. Nath. Because section assistant, as on today, it's out of question. Is itself once a graduate to be graduate, grade 3 post.
As on today, as per amendment for section assistant, HS science is
Section assistant, direct recruitment. It is science.
science. Because
It's not a grade 3 post.
it's a grade 3 post, but because they have a proportional avenue to the junior engineer. That is why science.
No.
HS.
Okay, and the sub-engineer probably would also need a science background. Sub-engineer, as on today, is it there or not?
In fact, Lord, in this case, if my friend has
No, let him complete. Let Mr. Das complete.
Your lordship, I beg to submit that at the time of his the gradation list prepared at that time, the petitioner was eligible for the promotion, lordship.
2005.
2005, your lordship. And earlier also a previous list was issued, and that is Annexure 6, your lordship, page number 20. This is
Page
28 May
20. 20.
20, your lord.
Yes.
This was issued by the Undersecretary of the Government of Assam, PWD Audit Branch, your lordship, addressing to the Accountant General Assam, ANE, Guwahati 5, creation of the post of Sub-Engineer Grade 2. Sir, I am directed to convey the sanction of the Governor of Assam to the creation of 833 numbers of post of Sub-Engineer Grade 2 for the period up to 28 to 94 in the scale of pay of rupees too much. For giving promotional benefit to the section assistants who have already completed 25 years of continuous service as section assistant as on 29/3/92 with immediate effect. The expenditure is debatable to the head of accounts from where those incumbents are drawing their pay, etc. at present. The detailed list of 833 number incumbents are enclosed herewith at Annexure 1, 2, and 3. This issue with the concurrence of Finance Department. So in this, your lordship, there have been in the chief PWD division, there are 3 people, your lordship, Mr. Motiur Rahman, Loknath Sharma.
Where page?
21, your lordship.
Nagaon.
So all of them were promoted, your lordship. And their qualifications similar to the petitioner, your lordship. But at that time, because the petitioner had not completed 25 years of service, so his name was not considered. But by that same logic, lordship, when the subsequent 2005 notice has been issued, at that time the petitioner's case could have been considered, lordship. Similar qualification and similar seniority, your lordship.
You said that since the government had taken a decision in 1993 to give the benefit of promotion to those section assistant who have completed 25 years,
yes,
and incumbents were indeed promoted, and you were left out because at that point of time you did not complete 25 years. But subsequently, when you had completed,
yes,
the same benefit should have been given to you.
Yes.
That is your case.
That is the main condition. Because in 2005, lordship, I had already completed almost 36 years of ideally, we could have been promoted when I completed 25 years of service, lordship.
But this page 20, this principle was followed at later stage or not? That is one issue.
Yes, the lord.
At one point of time, the government can take a decision that 25 years of service will be enough to promote one section assistant to the post of sub-engineer. Now, there may be a change of decision because sub-engineer invariably would require a science background.
And that is the true, your lordship. But
they have justified that last 5 years they have not given a promotion to a single person.
I have already reached the age of superannuation. My request is not for like promotion as on date, only for a notional promotion benefit, your lordship.
But this writ petition was instituted when? 2015.
Yes, your lordship. 2015.
We have the reply of 2011.
Okay.
The first round of litigation was withdrawn with a liberty to approach the authorities.
Yes, your lord.
You had approached the authorities immediately. That was replied on 2011. You come to this court in 2015. You already retired in the year 2009.
There has been a delay a little bit, but
Not
because
little
even the reply is very vague, your lordship.
No, you should have come immediately. 7/3/2011 is the reply. You are aggrieved by that reply. You come to this court in 2015. And if you are still in service, matter would have been still alive. Now, it's almost like flogging a dead horse. After 4 years, you have retired, you are trying to seek the benefit of promotion. And they have said that last 5 years, you have not promoted a single person. Okay, let's see. Yes, Mr. Nath.
Well, the petitioner, he retired in 2009, and the writ petition was filed in 2015 after 6 years. Well, the entire
No, but 9 will not count. will count from 11 because aggrieved
Lord.
order,
Lord.
impugned order is of 2011.
No,
Mr. Das, have your seat.
In
We'll come
fact,
to you.
Malad, on 7th of March 2011,
Have your seat, have your seat. Yes.
7th 2011 was intimated to him. This is not stated.
Hmm?
In the prayer portion, lot people not find.
7.3 is not challenged.
No, it is not in the prayer portion. It is not.
Mr. Das says that 7.3 is the impugned order.
Prayer at page 9. Why this reply is bad? They have not said. The entire projection made in the repetition is not the case of the. It kindly comes to page 9.
Okay.
Prayer. Issue rule calling of the respondents to show cause as to why a writ in the nature of mandamus, statutory, or any other appropriate writ, order, or direction of like nature should not be issued. Directly the respondents to grant the notional promotion benefit of sub-engineer grade 2 in favor of the petitioner with effect from 2005. 27/1/2005, that is the draft seniority list, till 31/7/2009, that is the date of retirement of the petitioner, along with all consequential benefit of promotion in the. So this letter is not delayed. But one more thing, Lord, he is claiming the benefit on the basis of a draft seniority. There is no appointment in the writ petition when the draft was made final, or that is the final position. That is one aspect here. The entire projection made in the writ petition is Lordship will find at para 13 and 14. That is basically his speech. He said that with ulterior motive, arbitrarily, some of his contemporary persons, they were given promotion in para 14. He has said that in 1993, government has created the. I'll read para 13 and 14.
Yes.
That it is pertinent to mention here in that earlier also the Undersecretary Government of Assam PWD Audit Branch by its letter dated 28/5/1993 to the Accountant General Assam Soyanto has conveyed the sanction of the Governor of Assam to the creation of 833 number of posts of sub-engineer grade 2 for the period up to 28/2/1994 for giving promotional benefit to the section assistant who had already completed 25 years of continuous service as section assistant as on 29/3/1992 with immediate effect. That letter he has annexed. Now, if kindly come to page 20, that letter for first is Nagaon NH Work Division.
Yes.
These are the three persons called Motiur Rahman, Loknath Sharma, and Lobok Kanto Deka. They are from Nagaon Division. The petitioner also belongs to that Nagaon Division. Now, he said in para 14, he said at page 6, as the petitioners have learned that two persons who were almost contemporary to the petitioner, namely Motiur Rahman and Lobokanto Deka. That page 21, serial number 1 and serial number 3.
Yes.
So there he said they are contemporary persons were given promotion from untrained section assistant to the post of sub-engineer grade 2, and in pursuance to the state letter dated 28/5/1993, and one say Loknath Sharma, who was junior to the petitioner, was also promoted to sub-engineer grade 2, but the state benefit was denied to the petitioner with ulterior motive. Lord, my respectful submission is, Lord, that if Loknath Sharma is junior and his name is included in a list who has completed 25 years, Lord, he should have raised his grievance at that point of time. So in 1993, Lord, he did not raise any grievance because the serial number 2 is Loknath Sharma.
Now, what is the date of this?
This is 93, Lord. Previous page, Lord, you will find 28/5/1993. Page number
79, 89. No, 93, Mr. Das has very categorically and fairly said that he did not complete 25 years.
Well, he said, but he
and
also.
Loknath Sharma cannot be 25. The seniority of Loknath Sharma, which is making a statement that Loknath Sharma is junior, that appears to be not a correct statement.
But he raised the grievance because while.
No, see, what is the heading of 21?
Yes.
List of untrained section assistants who have completed 25 years.
Yes.
Now, and admittedly, he was appointed in 69. So 1993, he has not completed 25 years.
1992.
93.
This list they have prepared with
93.
as on 29/3/1992.
Then he was not 25 years.
He was 23 years.
23 years.
My submission is, if a name, Loknath Sharma's name has been wrongly incorporated in that list, because the petitioner now says that Loknath Sharma is junior to, and he could have raised a grievance or he could have claimed that he has not completed, a junior person has not completed 25 years, his name has been incorporated in the list. So I may also be considered for that. or anything, because now the projection in para 14 is that he has been that benefit has not been denied, and with ulterior motive he has not been given from. But no representation, nothing. It is his statement that Sharma is junior. So then he said, it is submitted that in pursuance to the state apostate letter dated 28/5/1993, para 15, there were two persons, Motiu Roman and Lobakanto Deka, were from Nogao NH division and were section assistant there, where the petitioner had also served, and those two persons, Motiu Roman and Lobakanto Deka, were given promotion, and Sri Loknath Sharma was given promotion at that relevant time. And the petitioners have learned from reliable sources that other untrained section assistants who were serving at the different divisions at the relevant time were also given the benefit of promotion to the post of sub-engineer grade 2. And as the petitioner has completed 23 years of service till 1992, so he was not considered at that time for promotion. But thereafter again, as per letter dated 27/1/2005, when a draft seniority list of promotion of untrained regular section assistant to the post of sub-engineer grade 2 was prepared and forwarded by the respondent, and the name of the petitioner was serial number 16 in the state draft seniority list. And by that time, the petitioner had completed 36 years approx of his service, but the petitioner was denied with the benefit of legitimate promotion, for which he was entitled and untimely, and ultimately he retired on 31/7/2009. My respectful submission would be, he has not stated whether this draft seniority list was finalized or anybody from that list has been promoted, or only he said that draft has been prepared. You have drafted something in 2005. My name is serial number 16. Give me promotion from that thing. That is because Lordship has seen, in the year 1993, some posts were created for the purpose of promotion. Whether after the draft list of 2005, some posts were again created or they were promoted in those posts, or nothing is there. So in 2009 he retired, and the reply is specifically given at page 19. Lord has noted 7th of March 2011 that for last 5 years nobody has been promoted. If the petitioner could have shown that in 5 years some person from the draft petition list has been promoted, then he may have a claim. Therefore, in my respectful submission, just making a claim for promotion on the basis of a draft petition list of 27/1/2005, the right to claim promotion by the petitioner cannot be cut.
So, Lordship,
And there is no grievance as regard the reply of 7th of March. So why this is, or whether the true information given here, he has said that this is a vague reply. This is a vague reply he has mentioned, but this information that for last 5 years nobody has been given promotion, that he has not said that no, these are the persons here. They have been. The notional benefit, Lordship will consider at that stage if some junior person has been given the benefit, they price. Otherwise, not that.
Okay.
So, Lordship, one submission I'd like to make. In the reply given to my representation, only the statement has been made that no untrained second assistant has been promoted last 5 years, but there is no averment relating to the 2005 seniority list, Your Lordship. There is no and also this case has been filed in 2015, but the PW department has not given any affidavit in opposition, even contradicting the statement that we have given, Lordship. So if those statements have been there, maybe there could have been some verification whether the Loknath Sharma, whether he was actually junior to me or not, or even the seniority list was later finalized or not. It is not possible for me to find all the details, Your Lordship, and give it in a, but the fact that at the time of issue of the seniority list, I was eligible for promotion at the time, Your Lordship, as per my seniority basis, Your Lordship. And
You have not challenged the 7/3/2011. The reply.
that is, I admit, Lordship, that's not been given in the prayer board, but we have made averments, Lordship, in the body of the petition.
Regarding,
Regarding that the reply is vague and Lordship, and it's also not correct. I would like to read out the para 11, Lordship, if the Lordship permit.
yes,
That it is submitted respectfully in that the respondent number 3, the additional chief engineer planning, why it is aforesaid letter dated 7/3/11 had given a very vague reply that no promotion order for promotion was as untrained as they issued for last 5 years as claimed by the petitioner, whereas the petitioner has not stated any period within which such promotion was given effect, such as the period of 5 years, as mentioned in the state reply by the respondent number 3. And as such, the aforesaid reply dated 7/2011 of the respondent number 3 does not depict the correct picture, as in fact the other incumbent in the state department who were either contemporary or juniors to the petitioner were given promotion to the post of sub-engineer grade 2, but the state benefit was denied to the petitioner, and the moot question is not the period. Rather, the pertinent question is that the other persons were given benefit of promotion were either similarly situated candidate employees with the petitioner or junior to the petitioner, but the same was denied to the petitioner. As such, the reply by mentioning a particular period is nothing but an eyewash. That it is submitted respectfully that it is not a question that whether during a particular period any employee was given the benefit of promotion, but the grievance to the petitioner was that the petitioner was illegally denied with his legitimate due promotion, whereas others were promoted at a relevant time when the petitioner was in service, Your Lordship.
the instant petition filed under, please have your seat, Article 226 of the Constitution of India is on a claim for promotion from the post of section assistant to the post of sub-engineer grade 2 in the Public Works Department. Para. As per the facts projected, comma, the petitioner was appointed as a section assistant on 27/1/1969. Full stop. While in service, comma, a draft seniority list was published on 7/1/2005, in which the petitioner was placed against serial number 16. Full stop. On the issue of his promotion, comma, the petitioner had earlier filed WPC 3049 of 2009. Full stop. However, comma, the said writ petition was withdrawn on 3/1/2011, however, with liberty to approach the authorities with a claim for giving the benefits of the promotion. Full stop. It is to be mentioned that the petitioner had attained his superannuation in the meantime on 31/7/2009. Full stop. The petitioner had accordingly submitted a representation seeking promotion, seeking the benefits of promotion. Full stop. The said representation was replied on 7/3/2011 by the department by stating that there was no instance of promotion of untrained section assistant for the last 5 years, and there was also no provision for giving promotion to a retired employee. Full stop. The writ petition has been instituted thereafter. Full stop. Para. Thereafter, with the following prayers. Prayer to court codible. Para. I have heard Sri J. Das, learned counsel for the petitioner. Full stop. I have also heard Sri D. Nath. You are a standing counsel, periodicity. You are a standing counsel. Public Works Department. Full stop. Para. Sri Das, the learned counsel for the petitioner, has submitted that wide an office order dated 28/5/1993, 833 numbers of posts of sub-engineer grade 2 were created, and section assistants who had completed 25 years of continuous service were held to be eligible. Full stop. It is submitted that all along, similarly situated incumbents have been given benefit of the said office order. Full stop. The learned counsel has, however, fairly submitted that in the list appended with Annexure 6, the certain names of certain incumbents of various divisions, including the Nagaon division, where the petitioner was working, have been stated, and have been stated, and it was clarified that those incumbents had completed 25 years of continuous service as section assistant. Full stop. The list being of the year 1992, 92-93, admittedly, the petitioner was not having the experience of 25 years. Full stop. The learned counsel, however, submits that even after completion of 25 years of continuous service, no promotional benefits were granted to the petitioner. Full stop. In para. By drawing the attention of this court to the adjournments of the writ petition, more particularly in paragraph 13 and 14, the learned counsel has submitted that so far as the incumbents from the Nagaon division are concerned, one junior person was promoted to sub-engineer grade 2 with ulterior motive. Full stop. The learned counsel accordingly submits that suitable directions be issued to give the petitioner the benefits of promotion to the higher post, and consequently to grant all the benefits. Full stop. All the post-retirement benefit by treating him to have retired from the higher post of sub-engineer grade 2. Full stop. Para. Per contra, Sri Nath, the learned standing counsel of the department, has submitted that the earlier writ petition, which was instituted in the year 2009, was withdrawn with a liberty to approach the authorities. Full stop. Thereafter, the petitioner had indeed approached the authorities, which was replied to via the communication dated 7/3/2011. Full stop. By drawing the attention of this court to the relief sought for in the prior portion of the petition, comma, the Learned Standing Council has submitted that there is no challenge at all to the aforesaid communication. Full stop. He submits that the said communication contains reasons based on the materials on records, and unless such reasons are specifically challenged on sustainable grounds, comma, this court may not embark upon to decide the matter. Full stop. It is submitted that it is not the decision, but the decision-making process which can be the subject matter of an adjudication in a petition under Article 226 of the Constitution of India, and reasons having prescribed in the communication, comma, it clearly shows that there has been an application of mind to the relevant factors. Full stop. Para. Coming to the facts of the case, comma, the Learned Standing Council has submitted that even otherwise, the claim of the petitioner is based upon a draft seniority list of the year 2005. Full stop. He has submitted that there is no averment at all as to whether any final gradation list, well, as to when the said draft gradation list was finalized. Full stop. He has also highlighted the aspect that though in paragraph 14, an averment has been made that a junior person was promoted, comma, apart from the fact that the said person has not been made a party respondent, comma, the seniority list, the list of untrained section assistant is of the year 1992-93, and there is nothing on record to show that the petitioner had raised any objection in spite of the fact that he was working in the same division. Full stop. Para. The Learned Standing Council has also raised the issue of delay in approaching the court. Full stop. Para. The claim in this writ petition, as has been indicated above, is towards the promotion from the post of section assistant to sub-engineer grade 2. Full stop. The only document on the aspect of promotion, of such promotion, is a communication of 28/5/1993, which lays down the criteria as to have the experience of 25 years of continuous service. Full stop. As on the date of affecting certain promotions in the year 1992-93, comma, the petitioner was not having 25 years of continuous service. Full stop. The petitioner had approached this court in the year 2009 at the verge of his retirement, which was on 31/7/2009. Full stop. The said writ petition was, however, withdrawn on 3/1/2011 with a liberty to approach the authorities, which the petitioner had indeed done. Full stop. The said approach was replied to on 7/3/2011 by negating the claim of the petitioner by citing certain reasons. Full stop. If this court is of the considered opinion that they're having that the authorities having applied their mind to the claim of the petitioner and rejected with certain reasons, comma, unless the said order or said communication is specifically challenged, comma, this court would not be in a position to make any direction for giving the benefits of promotion. Full stop. That apart, comma, what is intriguing is to note that the person, the petitioner, who had already retired in 2009 and was communicated with the rejection of his claim in the year 2011, had approached this court after about 4 years. Full stop. Para. A court exercising powers under Article 226 is a court of equity, wherein the conduct and bona fide of the incumbent approaching this court is of paramount importance. Full stop. Approaching this court after 4 years in the present case, that too by an incumbent who had retired in the year 2009, will not entitle the petitioner to have any equitable relief. Full stop. Further, comma, this court has noted that the incumbents who were given the promotion have their names in the list prepared in the year 1992-1993 with a specific, under the specific heading of having completed 25 years. Full stop. If any incumbent was given undue benefit, comma, the petitioner should have made an objection, which objection at that time itself, which is not seen to be done. Full stop. Even in the present writ petition, comma, the said incumbents have not been made party respondent. Full stop. The reasons cited in the reply dated 7/3/2011 appears to be bona fide and in accordance with the and as per the records pertaining to the issue of promotion. Full stop. Para. In view of the aforesaid discussion, comma, this court is of the opinion that no relief can be granted to the petitioner. Full stop. Petition accordingly stands dismissed. Yes.
Yeah, this is your lordship. Your lordship, here the petitioner is a requite plumber, your lordship. As a tradesman requite rally that has been posted for 2018 to 2019, your lordship. As regards to that, your lordship, one provisional appointment.
You are what?
Your lordship, he has applied for the state post, your lordship, that is
What
requite
post?
plumber. And according to, for issuance of 2018 to 2019 year.
Just a minute.
And a
Just a minute.
provisional appointment.
Just a minute. Go slow, just a minute. He does. You appear in a
Plumber.
recruitment for plumber post. Plumber. Where under the Assam Rifle?
2018 and 2019, which was issued by Assam Rifle Training Center.
Plumber post.
Yes, Your Lordship. That
In Assam Rifles.
in Assam Rifle, Your Lordship. And thereafter, Your Lordship, on 19/11/2009, 2019, Your Lordship, a provisional appointment was issued upon respondent, which I have
19?
annexed in page 30.
1911-19.
19/11/2019.
You are promoted provisionally.
Yes, Your
Appointed
Lordship.
provisionally.
Provisional, Your Lordship.
Provisional
Then-
appointment.
Appointment at page 30.
30.
30 of
Let us-
my affidavit,
let
of
us-
my petition.
Let us see 30.
Annexure 4.
Yes. What happened thereafter?
Thereafter, Your Lordship, I proceed for Your Lordship physical training, Your Lordship. And thereafter, Your Lordship, physical training was given, Your Lordship. Thereafter, without showing proper causes, Your Lordship, one that I has annexed as annexure 11, Your Lordship, page 30, page 33, annexure 7. 21 April 2021,
33.
33.
What is this?
Your Lordship, showing that this is the impugn order, Your Lordship, which has been issued upon me on dated 21 April 21/5/2021, showing that due to unsatisfactory progress in training,
Now you are what?
Your Lordship. I am the petitioner, Your Lordship.
No, what has happened by this?
This shows that due to
Discharge.
discharge, Your Lordship, discharge of the service and discharge from its service, Your Lordship, from requisite plumber, that is Ravi Ranjan Kumar, from service on 21 April 2021 due to unsatisfactory progress in training.
Discharge. Answers.
Where rule says so, Your Lordship, annexure
Okay.
11, that is page 45.
Progress in training.
Yeah.
Okay. You are challenging this order of
This
discharge.
order, Your Lordship.
Okay.
Extracted portion of the rules I have annexed as annexure 11,
Mm.
page 45. 21. 21(2). I would like to read it, Your Lordship. In all cases of recommendations for discharge of a person, the commandant of the training page 45, annexure 11 of my writ petition.
4-5.
45. Annexure 11. 21(2).
This is what rules?
Assam Rifles rules.
Name of the rules.
Assam Rifles Act 2006.
Assam Rifles Act.
Rules 2010, sorry, Your Lordship. It's Assam Rifles Rules 2010.
Assam Rifles. Mr. Locker, what is the name of the rules?
Assam Rifle
Rules or Act?
2010.
Act.
This is, I think these are rules.
Rules. They have also annexed it in their affidavit, Your
Assam
Lordship.
Rifle Rule 2010.
10.
Assam Rifles Rules 2010.
10.
You are referring to Rule 21.
21(2).
Yes, please read.
In all cases of recommendations for discharge of a person, the commandant of the training establishment shall establish clearly the fact that the person has been given suitable warning and sufficient time to show progress. Documentary evidence to this effect shall accompany the recommendation. Here it shows clearly, and it states clearly that suitable warning and sufficient time to show progress should be given by the petitioner, which they did not give it, Your Lordship.
Okay.
Now taking.
Now, let us see your averments that you are not being afforded sufficient time,
Yes, Your
suitable
Lordship.
warning,
That's-
documentary evidence. Where
Your
are you aver-
affidavit in opposition, I would like to take.
No, no, where have you averred that 21(2) has been violated?
Page number 11, Your Lordship,
Yeah.
paragraph 10, Your Lordship. That the petitioner begs to state that he visited the offices of the concerned authorities several times as he was not given any reason for his termination from his service but failed to evoke any positive response. Thereafter, on 9/8/2021, an RTI was filed by the petitioner for requesting the respondent number 3 to furnish him a copy of the documentary evidence that substantiated his discharge with reference to the above mentioned impugn order dated, which has been issued upon 21/4/2021 upon the petitioner. But no response had come from their end. Thereafter, the petitioner filed the first appeal on dated 15/9/2021 before the concerned authority. And as regards to that, but no response has came till date, Your Lordship, which I have already annexed as 9 and 10 annexure. 36 to 39 page.
Okay.
Annexure 9. And regarding to that RTI, Your Lordship, they have made their submission, Your Lordship, in their affidavit, paragraph 10. I would like to read their affidavit, Your Lordship. That with regard to the statements and averments made,
Paragraph?
paragraph 10 of their affidavit, page 7.
Just a minute, please. Please read.
That with regard to the statements and averments made in paragraph 10 of the writ petition, the deponent, while denying the same, begs to state that the statements are false and misconceived. The petitioner has not visited the respondent authorities, and also no application under RTI Act 2005 has been received by the department as per the records. Respondents, however, submit here that the Assam Rifle is exempted from providing any information under RTI Act. That has not been given, Your Lordship, as we have already annexed it as annexure 36, 37, then 38, 39. This is the documents, Your Lordship, they had received it, which. And thereafter, Your Lordship, I would like to read below paragraph 11 of my writ petition, that is on page 12. That the petitioner begs to state that no proper explanation was given to him while discharging him from the basic training, which is in violation of Rule 21 to 21, to which I have already read it, Your Lordship. In case of the recommendation for discharge of a person, the commandant of the training shall establish clearly the fact that the person has been given suitable warning and sufficient time to show progress. One, documentary evidence to the effect shall accompany the recommendation. That states clearly, which I have annexed it and already read it in annexure 11.
No, let us not go to the issue of replying to the RTI. Now you are before this court.
Yes, Your Lord.
You have made us very specific averment that 21(2) has been violated.
To that, Your Lordship, I would like to take their affidavit in opposition. Page 12. For equity relief, Your Lordship, I am praying it, Your Lordship, as on dated 9/3/2021, one annexure has been annexed. Being as a rifleman, Your Lordship, page 12 of their affidavit, Your Lordship.
Order by the court.
By the court, Your Lordship, Honorable Justice Michael Zotankama,
Yes.
Your Lordship.
Yes.
On dated 9/3/2021, Your
How is
Lordship,
it relevant?
being as an rifleman, paragraph 2, it shows that it was enrolled as rifleman. Being as an rifleman, he has already get 4 times, Your Lordship, page 14. As petitioner failed in BPT, he could not able to complete his BPT, that is battle physical efficiency test, Your Lordship. Whereas this is requisite plumber. If they would give him one chance also, Your Lordship, it won't affect to their
No, this is
Your
not
Lordship,
relevant, madam. We are not going by that. We are going by the provisions in the act,
provision,
rules.
Your Lordship. BPT has been given 4 times, Your Lordship, to the rifleman. But
We are not concerned with the rifleman. We are
And-
concerned with your appointment as plumber. You can be discharged on 3 conditions. Let us know from Mr. Locker what are the conditions.
And Your Lordship, as per your conduct of recruit training that has been annexed as annexure to page 15 of their affidavit, medical EME engineers week that comes under the plumber. That is for plumber.
Page
Page 15.
15,
That
yes.
conduct of recruit training, tabulation.
Yes, yes.
Medical EME engineers weeks.
Hmm.
That falls under plumber. Your Lordship, it clearly shows 23, and there below, Your Lordship, 3. That 3 changes, Your Lordship. That 23, if we give 23 plus add on 23 and 23, equate to 23, 23, 23, it shows 69 weeks total weeks, 69 weeks, whereas petitioner has been discharged in 44 weeks. Rest weeks, he did not get it, Your Lordship.
You should get 69 weeks.
69, 23 weeks below, it was clearly stated 3 weeks, 3. So if we calculate it, then 69 weeks come.
How, this is something else, academics.
No, Your Lordship, it was clearly in the below itself, Your Lordship, 23 weeks. Otherwise, in 23 weeks, the whole procedure could not be completed, could not be able to complete it. And regarding about tabulation, they have not mentioned anything, just annexed it as annexure.
We'll get it clarified from Mr. Locker. Don't worry.
Lordship. Maybe, sir.
Anything else? Anything else?
Then, Your Lordship, I would like to take you for the, page 19 of their affidavit. Basic training,
Page 19.
page 19. Yeah. Yes, sir. Basic training. For plumber, it ends in DIG check test. Whereas petitioner has successfully completed till road march, 2nd attempt, 3rd attempt. Then thereafter, Your Lordship, drill square test and PPT. Where he fails, it has admitted that in drill square test and PPT, the petitioner failed. Thereafter, Your Lordship, if he does not clear that drill square test, he would not be sent to DIG check test. Where DIG check test, he gone to DIG check test PPT, where he has failed in PPT, that is for one touch. For one touch activity, he had failed. So thereafter, no proper explanation has been given, and the time period he would be gave, Your Lordship, he was not given. So Your Lordship, that time period, I am challenging Your Lordship. As without completion of drill square test, he would not been sent to DIG check test. He was sent to PPT, Your Lordship. There, Your Lordship, in PPT, that for one activity he has failed. He has declared to be failed. And relegation policy also, that is page 20 of their affidavit, relegation policy.
No, these are general,
Relegation
SOP kind of a thing. How?
SOP, yes, Your Lordship.
Now, let us have the reasons from Mr. Locker. Yes, Mr. Loker.
Lordship. So here in this case, Lordship, what happened, Lordship, he joined in service, Lordship, on 23rd, 12, 20, in 2019, Lordship. He joined in his job,
Joined when?
23, 12, 2019.
23/12/2019. Petitioner joined.
Lordship. He's joined, Lordship. And thereafter, Lordship, his training period started, Lordship.
Joined as a recruit. Recruit plumber.
Plumber, Lordship.
And his training started.
Training started. And as per rule, Lordship, he has to complete his, he has to appear before the board for training board, Lordship, because for on Lordship, within Lordship, 23 weeks, Lordship. That, Lordship, I will say, Lordship,
He has to complete the training within 23
3
weeks.
weeks, Lordship, and he will appear before the
No,
Complete.
that is, Lordship, page 19 of my affidavit, Lordship.
Then to appear before whom?
Lordship, that is the training, Lordship.
No, no. After 23 weeks of training, he will appear before what? Board.
Not for Lordship. That a training period will complete, a examination will be held, Lordship, and that if he pass, then the entire process that passing from he will appear, and thereafter the entire process will be within 8 weeks or 44 weeks. Everything has to be completed, Lordship.
No, no. What is 23 weeks?
23 weeks, Lordship, his the first relegation, Lordship. He will appear, join. Thereafter, some training period is there. Thereafter, he will give a test, Lordship. That is a test, Lordship.
After 23 weeks, he will give a test.
First test, Lordship.
Oh.
And if he pass,
Oh.
there are two tests, Lordship, PPT and BPT. PPT means, Lordship, that is the PPT is, Lordship, physical proficiency test, and the BPT is battle proficiency, which is battle physical efficiency test.
Proficiency
Test.
test and battle BPT.
Physical efficiency test.
Battle BP
And
battle physical
Mental physical efficiency test.
BPET.
BPT, Lord.
Battle physical efficiency.
Lord.
Test.
Here, in the case of Lordship, it is known to all Lordship that in the case of Lordship, armed forces and other Lordship, it is not like that, Lordship. He is only a plumber, so he need not.
No,
to
no,
go
no,
for
no.
that
You
thing.
need to.
He has to do everything, Lordship.
That we know.
That is the first thing, Lordship. And
No, you said that we have understood. After 23 weeks, he has to appear in a test.
test, Lordship.
Test consists of PPT, BPET.
BPT 20
Both the segments.
Lordship, in 22nd, in 22, it will be PPT. In 23rd weeks, it will be BPT.
22 weeks. But they have not stated in their affidavit. Your
Probably
Lordship.
come
Let
to
them send.
1 to 22 PPT, 22 weeks.
Then BPT in 23rd weeks.
After 22 weeks. After 23 weeks.
Lordship. If he completed his training, if he passed in that training, Lordship, then the next DIG checklist, that and the remaining portion will come, Lordship.
What are the remaining portion?
There are so many,
checklist
Lordship.
is the
DIG check, Lordship.
DIG check means
Lordship. That is, Lordship. If he could pass away, then there will be DIG check this, Lordship, and thereafter, Lordship, his attestation will be given, Lordship, as a complete, Lordship.
DIG
Lordship,
checklist.
if
What is the term you're using? DIG
Lordship, page 19, Lordship, may kindly come, Lordship.
of your
My
affidavit.
affidavit.
Yes.
Page 19 of
DIG
my
check
affidavit,
test.
Lordship, yes, A, B, C. For them, C is the last, Lordship.
What
First
is-
PPT, then BPT, BPT, then DIG, Lordship.
Where at page 19?
19, Lordship.
Where, which one?
Sorry, Lordship, no, Lordship on
Page 19,
19.
C.
See is DIG checklist.
Two DIG checklist test is there, Your Lordship. One is
of my
B and
affidavit, Lordship.
another is C. Page 19 of his affidavit, Your Lordship.
Yes. DIG check test. What is DIG check test?
Regarding DIG check, I have to approach the part because he could not come to that proportion, Lordship. He
PPT you have to complete within
Lordship.
22 weeks.
22 weeks.
And
BPT,
BPET
the
within
next day, 23 weeks.
These
But
are
he
for
could-
trade and tradesmen,
Okay.
23 weeks, okay.
If he could not pass out, then he will have to back again, and he will get 2 weeks more to complete his training again, Lordship. That I will show, Lordship, from the record, from the SOP, Lord. Or he
Now,
will.
in this case, what happened to the petitioner?
Lordship,
He could not pass
He could not pass, Lordship. He could not pass the DPET test, Lordship. Thereafter, he has to back
back for
again,
2 weeks.
and he joined in the next batch, Lordship. Normally, he should get only 2 weeks, but here in this case, as the next batch was not coming, for him only it could not be conducted. So, Lordship, the next batch he got 22 6 days, Lordship. The next batch he again after 2 weeks. After 14 weeks, Lordship, he got, Lordship.
Next.
Lordship. Because, Lordship, on first, Lordship, may I give the dates, Lordship? First relegation was done on 1/6/2020.
What is this first?
First relegation. It means first.
He failed and he had to send back for 2 weeks.
2 weeks.
Oh, yes.
The second relegation, Lordship, then again the second relegation started. Then it was on 10/8/2020.
Second relegation.
Second relegation.
Why
Second relegation,
batch were
11.
not there or what?
Second relegation 16/11. They have stated B.
Sorry. Actually, as per rule, Lordship, if he got only two weeks, so he should be he should join on 10/8/2020. But instead, Lordship, he joined on he got 16/11/2020. So again, he got 14 weeks, Lordship. Instead of 2 weeks, he got 14 weeks, Lordship.
16/11/2020.
So
No,
again in third weeks.
Mr. Locker, why didn't you place it in a very simple manner? You said that for PPT one gets 22 weeks and for BPET you get 23 weeks.
3 weeks.
He did not pass,
He could
so he
not
did
pass.
not reach to the stage of DIG check test.
Okay.
He was supposed to be given 2 further weeks.
100 weeks.
He got 14 weeks
14
further
weeks, 100,
because there
14.
was no batch coming.
Lordship.
Thereafter,
Again, he got, Lordship. Again, he got 9 weeks, Lordship. For third, again, he will get 3 chances, Lordship.
first chance when did he get?
First chance on, Lordship. First, he within 22 weeks that exam was held.
No,
Lordship.
that is the
That-
first. That is not
first-
the relegation.
first-
That is the first chance. He failed.
Lordship.
Second chance.
Second chance, 14 weeks, he got another.
When was it?
It was held on 16/11/2020.
Second chance. Yes.
And third, again, if he again failed, then he will join the next base. Third, he appeared on 10/3/2021. So again, he got 3 weeks.
Third attempt.
He again failed.
After how many weeks?
9 weeks, Lordship. After 9 weeks, Lordship.
Again failed.
Again failed, Lordship. Now, Lordship, he, as per rule, Lordship, he will get a show cause notice, Lordship. And that is, Lordship, at page, Lordship. He has been given a show cause notice, Lordship, for this, for improvement of his
Or you had given a chance to
chance,
improve.
Lordship. The last chance, Lordship, that is the rule, Lordship, that as a fourth chance, Lordship, he has been given.
Where? Page
Lordship, page
27.
27,
of your affidavit.
Lordship, of my. First relegation is mentioned here, second relegation is mentioned here, third relegation is mentioned here. The last attempt DIG check test of your PA was conducted on Iman March, where you have again failed. You are hereby warned to improve your performance to clear PPT test by 7 April 2021, failing which action will be taken against you for this.
So again, he appeared before the board lordship. That is on 7/4/2021. And here also he again got 4 weeks lordship. But he failed again now. He could not pass the board.
Where is the statement that after this scope also he had failed?
Lordship, that is my
To clear. On 4th April.
para 3 lordship
Board
of my affidavit.
Scheduled on for 7th April.
Lordship. 7/4/2021.
You held the test, again failed.
Again failed.
Where have you stated?
Para 3 lordship.
Of your affidavit?
Yes, I have mentioned it in para 1, 2, 3, the entire process. Right? In para 3, that specific line is there of my affidavit.
Just a minute, please. Para?
3 lordship of my affidavit. In para 1, the first delegation, second delegation, and third delegation I have mentioned. In para 3 lordship, that specific lordship, that training, delegation, and that training, relegation, and discharge of recruits in Assam rifle is governed by the policy instructions laid down in the standard operating of procedure SOP issued by the Assam Rifle Training Center and school letter number para 12 and 13 of SOP provide for relegation of recruits for maximum 3 times on retested by a board of officers thereafter, and if she again fails, her discharge on the ground of unsatisfactory progress in training. Therefore, after relegation, price a show-cause notice was issued to the petitioner in terms of Rule 21 Assam Rifle Rule 2010 and para 13A of the SOP by the Assam Rifles Training Center and school letter number wherein he was warned to improve his performance to clear PPT test by 7/4/2021 as per para 13(3) of the SOP. The petitioner was screened by a board of officers and his test was conducted again on 7/4/2021. However, he again failed in the test conducted by a board of officers, and accordingly he was recommended for discharge from service by the board on the ground of unsatisfactory progress in training. And why I'm saying lordship, that procedure lordship, that he will join the next best lordship, that is at page 21 of my affidavit. The failure that is of the SOP lordship. Page 21 of my affidavit. 16. Failure, point number 16, failure during
Madam, the preconditions for taking action under Rule 21 have been taken, have been given all the opportunities.
But regarding the tabulation, your lordship, they nothing have mentioned it clearly, elaborately, your lordship. Just simply annexed it, your lordship. So to that, your lordship, kindly a detailed affidavit may file by
No,
that.
why detailed
respondent.
affidavit? They have stated the entire facts. 3 relegations were there. You could not clear. Show cause notice to improve. Another 4 weeks. It was scheduled on 7/4/2021. You again failed.
Regarding the time period, your lordship.
Time period.
That is lordship in page 21.
We are trying to have a look at the decision-making process. They have followed the rules, and it's not a question of victimizing. You had been given all the chances.
And instead of 2 weeks, he has got 20 weeks, 9 weeks, 14 weeks, 9 weeks, like that lordship. In para 21, that is as it is mentioned in the para 20, page 21, para 18, point number 18.
And
failure during
we are
test.
trying to look at any materials which could have given an idea that there were some extraneous factors or consideration. There is none. You have been given due chances. You had got more than sufficient time. Only batches were not there. First relegation 1/6/2020, second 16/11/2020, third 10/3/2021.
First, second was, Your Lordship, clearly it was stated regarding first relegation and second relegation. Failure of first and second was elaborately stated. But in the third relegation, it was simply mentioned that failed in PPT test, which was held on 10/3/2021.
Yes.
If he would not pass the following other relegations, he would not been allowed to the DIG check test, Your Lordship. There only, Your Lordship, only PPT portion, Your Lordship, one activities the petitioner has failed, Your Lordship.
No, unless you pass the PPT and BPET, you do not,
Regarding the time
you do
period,
not
Your Lordship.
reach the stage of DIG checklist.
Once he fails in any of the examination, it will be counted from the very beginning. It is the rule 40 Your Lordship. As the period.
Maybe you are fit for some other jobs, madam, not in the Assam Rifles.
Page 20, 14, rule 14. For subjects like PPT, and firing failure in any subject test will be considered as failure in that complete test. So here PPT and PPT was there. If he passes with the PPT, and fails PPT, then it means he could not pass in all the attempts.
Okay.
And page para point number 16.
We'll pass the order at 2 o'clock.
Lord.
DP Oblet.
Lordship, some accommodation for sale of item number 2 can it be taken up on Tuesday? Even until for respondent.
You're for whom?
I'm for the petition. Item number 2.
As for all this.
Okay.
Only for today, Lord.
We'll see. Let's see. Is the 15 matter?
Lordship, 15 matter, Lord.
Why are you seeking time?
Lordship, Mr. R. Muzumdar was to appear, but he is already on lake at port number 2, Lord. 2 o'clock
But these
also.
matters we have already we have decided special police court. Okay, item number 2. On a joint request, a short accommodation is granted, directing listing of this matter on 2020, no? The 20th, 20.
Highly obliged, Lord. Obliged, Lord.
Episode কি আছে? 6, Mr. Mohanta is
Mr. Mohan.
Okay, well, 17 matter, Mr. When do you want, Mr. Mohanta?
Next Tuesday, my lord.
Next Tuesday, have fixed a number of matters.
Thursday, my lord.
Thursday, sir. Who's for the other side?
I'm there.
Item number 10.
11.
10 and 11. You are for 11?
Yes.
Next Thursday?
Yes.
On a joint request made by the Learned Council for the parties. List on Thursday next.
Obliged.
Last submission, Your Lordship, whatever he has stated, Your Lordship, regarding the weeks of PPET and PPT in the tabulation, that has not elaborately.
You have
Your
said,
Lordship. mentioned in the affidavit.
An order dated 21/4/2021. Please have your seat. By which the petitioner, who was serving as recruit RECT/plumber, has been discharged, is the subject matter of challenge in this petition filed under Article 226 of the Constitution of India. Para. As per the facts projected, in a recruitment held, the petitioner was successful and was provisionally appointed as plumber vide an order dated 19/11/2019 in the Assam Rifles. Full stop. In the said letter of provisional appointment, it was specifically mentioned that on the failure to successfully complete the recruit training within the stipulated period, his services was liable to be terminated without any notice or assigning any reasons. Full stop. It is the case of the petitioner that the statute holding the field, namely the Assam Rifles rules of 2010 contains the provision of discharge, full stop. As per Rule 21, before discharging a person under a person on account of unsatisfactory service, he has to be given adequate warning and sufficient time to show progress. Full stop. It is also the rule also stipulates that there should be documentary evidence to justify such discharge. Full stop. It is the case of the petitioner that in violation of the aforesaid provision, namely Rule 21 within bracket 2, the impugned order has been passed. Full stop. Para. I have heard Ms. P. Das, learned counsel for the petitioner. Full stop. I have also heard Sri P.S. Lohkar, learned CGC. Full stop. Sri Lohkar, and CGC, who submits that affidavit in opposition has also been filed on 29/4/2022. Full stop. Para. Ms. Das, the learned counsel for the petitioner, has submitted that the petitioner tried to redress his grievance by filing an appeal against the impugned order dated 21/4/2021, and the said appeal was also not responded to. Full stop. She has also contended that the recourse of the Right to Information Act was taken, in spite of which no information was received. Full stop. Para. By drawing the attention of this court to the affidavit in opposition, comma, the learned counsel for the petitioner has submitted that certain tabulation has been annexed therein, from which it would appear that the petitioner was not fairly dealt with. Full stop. It is submitted that no justification or adequate reasons have been cited for discharging the petitioner. Full stop. It is also submitted that the materials on record would show that the finding arrived at regarding the petitioner being unsuccessful is also belied by the fact that the petitioner appears to have been crossed the initial stages and has reached the stage of DIG's S apostrophe check test.
Fine.
Full stop. It is also contended that no suitable warning as per Rule 21(2) was given to the petitioner, and the impugned order is not backed, is not supported by any documentary evidence. Full stop. Para. The learned counsel for the petitioner accordingly submits that the impugned order of discharge dated 21/4/2021 be interfered with and a direction be issued for allowing the petitioner to undergo the test for confirmation in his service. Full stop. Para. Per contra, comma, Sri Lokor, the learned CGC, by drawing the attention of this court to the affidavit in opposition filed on 29/4/2022, has submitted that the provisions of Rule 21 within bracket 2 of the rules of 2010 have been duly complied with. Full stop. It is submitted that on 23/12/2019, comma, the petitioner had joined the Assam Rifles as a recruit plumber, and thereafter the training started. Full stop. As per the norms, comma, such a trainee is given 22 weeks to pass the physical proficiency test within bracket PPT and 23 weeks to pass the battle physical efficiency test within bracket BPET. Full stop. It is only when a recruit is successful in the aforesaid two tests as above, comma, he attains the stage of DIG apostrophe S check test. Full stop. In case a recruit is not able to clear the first two aspects of PPT and BPET, comma, he is given further time. Full stop. In the instant case, comma, the petitioner had failed to qualify in the PPT and BPET, and therefore, as per the norms, comma, he was supposed to get 2 further weeks. Full stop. However, comma, since the first batch, next batch was not yet ready, comma, the petitioner got extra time and he had applied for the second chance on 16/11/2020, where again he had failed. Full stop. After 9 weeks after 9 weeks, the petitioner was given a third chance on 11/3/2021, wherein also he had failed. Full stop. 10/3/2021, wherein also he had failed. Full stop. Thereafter, on 20/3/2021, a show cause notice was issued to the petitioner to improve his performance within a period of 4 weeks. Full stop. The petitioner had thereafter appeared in a further test on 7/4/2021, in which he had failed. Full stop. It is only after that the impugned order of discharge has been passed on 21/4/2021. Full stop. The learned CGC has submitted that in the organization concerned, namely Assam Rifles, irrespective of the nature of the posting, all personnel are required to undergo the basic test, including PPT and BPET, and failure on those aspects would be construed to be a disqualification for a confirmation in the services. Full stop. Para. To appreciate the rival submissions, it would be convenient if the concerned rules are taken into consideration. Full stop. Rule 21 within bracket 2 of the rules of 2010 reads as follows. Page 45, 21(2). Quote. The rule stipulates that if that while a discharge is permitted, such discharge is to be preceded by suitable warning and sufficient time to show progress. Full stop. Further, documentary evidence is to accompany the recommendation. Full stop. In the instant case, as per the projection of the petitioner, the aforesaid provision has been violated. Full stop. Para. It is not in dispute regarding the necessity to qualify in the PPT within 22 weeks and BPET within 23 weeks. Full stop. The petitioner had failed in the first attempt held on 1/6/2020, when he was given a further chance. Full stop. Though the period granted is 2 weeks, so far as the petitioner is concerned, he got about 14 weeks due to certain exigencies. Full stop. Even in the second chance held on 16/11/2020, the petitioner had failed, followed by a third attempt on 10/3/2021, which was held after 9 weeks. Full stop. The petitioner having failed in his third attempt, the show cause notice was issued to the petitioner. Full stop.
Page 27 of their affidavit. So good.
Incidentally, comma, the said show cause notice has not been annexed in the writ petition, and it is only in the affidavit in opposition, comma, the show cause notice has been annexed as annexure A4, full stop. There is no denial of the show cause notice by the petitioner, full stop. In the affidavit in opposition, comma, it has been categorically stated that by the aforesaid show cause notice, comma, the petitioner was given a further chance to improve his performance, and in the test held on 7/4/2021, he had failed again, leading to the passing of the impugned order of discharge, full stop. The affidavit has also enclosed the tabulation pertaining to the requirement of the rules, including the period granted to clear the PPT and BPET, full stop. This court, on examination of the materials on record, is of the considered view that the requirement of Rule 22 or 21 within bracket 2 have been complied with, full stop. This court is also of the view that the organization in question is a highly disciplined force wherein each of the recruit are to pass the various tests towards their proficiency and to be battle competent, full stop para. The order of discharge does not appear to sustain from any procedural or legal infirmity, and accordingly the writ petition is dismissed.
Deputed.
Said Peter this matter is state by Sri character today. Please 60 down legs at court number 17. One perfect matter is going on first. Lordship, may I pray to take up this submitted?
There is a stay order, madam. We wait for some time.
Yes.
If it reaches, we'll take up. Otherwise, we'll see.
Right.
If he's free, just ask him to come when the matter is over. Okay. Item 19 and 20.
Lordship, in this item, Lordship has directed Lordship to file affidavit on by 9th Lordship, 9th of August. But we have prepared and we have sent for waiting. Now they have given a communication, Lordship, where the authorities are trying to sort out the issues, Lordship.
What is the matter, madam? Mr. Kaushik?
Malad, in the WPC 5525, Malad, we have challenged the promotion, Malad. We have been deprived from promotion.
Okay. They are trying to have resolve the matter.
Yes, Lordship.
But
Are you aware? Do you have the
Consider it
instructions?
I don't have any instruction, Malad. In the last
Are you in
occasion-
touch with your clients or not?
Yeah, I'm in the touch with the client.
Ask
They
him
don't
to
know.
ask him to have some information. Okay.
They don't know, Malad, if it is an internal communication between the
I
No, no,
I have,
record it.
I
Will-
have placed one the communication, Lordship, where they have sought for at least
Yes,
4
yes,
weeks
there
time,
is
Lordship.
the written communication.
Right.
Okay. Heard Sri B. Kaushik, Learned Counsel, for the petitioner. Two petitions, same person,
No, Malad.
Same.
There are
sir.
10 petitioners.
10 petitioners. Lordship.
petitioners. in
Both
these,
cases.
huh?
Two cases are 19 and 20
There
item
are two
number.
writ petition, my
Two
lord.
writ petitions, lordship, of the same petition. One is 383320.
Bahir,
3835.
to write.
3835, my lord, the challenge is where we have been given the seniority without the benefit.
Orders लिखी बोलेंगे ना. কি করলো? In these two cases, no, hard three बोलो नहीं. In these two cases, full stop para. Ms. M. Bhattacharya, learned additional senior advocate, Assam, has however submitted that though the affidavit in opposition is has been prepared and will be filed shortly, full stop. As per the latest instructions received, via communication dated 12/8/2024, comma, the cases of the petitioners appear to be under consideration. Full stop. The said communication dated 12/8/2024 is placed on record. Full stop. Para. In view of the above, comma, matters are adjourned to be listed after 4 weeks.
Lord.
On the next date, comma, both the learned counsel for the parties would obtain the up-to-date instructions.
Lord.
Can a date be fixed, my lord?
List on 13th of September.
13th of
Yes, Friday.
Great.
Applies to.
For hearing.
May it please your lordship.
Yes, what is this?
This is challenging a selection procedure.
May I please your lordship, for item number 9, PN Sharma appears, but he is not there as he is out of station due to some personal issues.
16 matter, madam, and you are Mr. Doctor.
Item number
Doctor for which matter?
For item number 8.
8. What is the matter?
My lord, it's a matter of 2016, my lord. The petitioner participated, my lord, in the selection of, my lord, AFPF constable. And my lord, the contention was that, my lord, there was no prescribed criteria either in the advertisement or prior to the physical efficiency test for shortlisting of candidates. Because, my lord, the petitioner, my lord, participated in the physical efficiency test and he qualified as per the norms prescribed. But, my lord, finally, my lord, he was not called for, my lord, for the Viva Bosi, and therefore, my lord, this petition was filed seeking mandamus to direct the respondent authority to select the petitioner for Viva Bosi. And, my lord, while, my lord, the very first order, my lord, while passing that order, my lord, there was no such, my lord, interim protection, my lord. But, my lord, this court, my lord, while passing the order, made an direction to the respondent authorities to apprise this court what is the cutoff mark for selection of MOBC and OBC candidates. Because the petitioner is, my lord, he belongs to MOBC.
In your case, how many petitioners are there? One petitioner.
One petition.
One petition.
And madam, your case, one petitioner. You do
One.
not know. One petitioner.
You don't know.
After selecting the selected list, so they have not made the particular candidates have been selected for the.
No, otherwise you have the cutoff mark for,
Yes, we are file an affidavit, your lordship.
and they secured less marks.
Less mark, I thought. They have secured that less.
My lord,
See, Mr. Doctor, shortlisting you cannot find fault with unless you can allege malafide. And if the cutoff given by them is somehow less than what you had secured, then matter would have been different. Second, the more important point is the selection of 2016.
Yes.
In 24, perhaps will not be able to grant you any relief. Madam will finish this matters. No need of adjournment. If there was any merits, we no. There is 16 matters. Unnecessary, it's a burden for you, burden for the court. Let us finish this off.
My lord, but my lord, their affidavit is not clear, but the criteria, that is 24 is the criteria, minimum criteria for selection of MOBC. There is no such type of, my
They'll
lord.
say cutoff criteria.
It's
What is the
cutoff.
criteria? We'll go by the cutoff. You don't know how many marks they have secured.
They have secured
21.
21.5, but the cutoff is 35.
No,
Will-
cutoff is not 35.
35 out of 35. In our affidavit, we have stated that the cutoff.
Cutoff mark, that is 24.
And you have secured?
21.5.
21.5. Cutoff is 24 out of
And
35.
the other one?
The other one, they have, he has secured 12.5.
Okay.
Petitioner, my lord, he also, my lord, contended that, my lord, everything was videographed, my lord, and whatever required, my lord, he has photo. But, my lord, regarding
Okay.
that part,
Hard-
my lord, they have not.
Heard Sri M. Doctor,
Yes,
Learned Council in WPC 990 of 2016. And Miss, what is your name, madam? S. Shankar. Learned Council appearing in instruction of Sri P.N. Sharma. Learned Council for the petitioner in 557 of 2016. Para. Also heard Sri R. Gogoi. Learned Standing Council. Forest Department. Para. Both these writ petitions being on the same subject, comma, those are taken up for an analogous hearing and are disposed of by this common judgment and order. Please have your seat. Our recruitment process was initiated for the post of AFPF. What is AFPS? PF? Assam Forest Protection Force.
Assam Forest Protection Force.
For Assam Forest Protection Force Constable within bracket AFPF. Wide and advertisement dated 23/4/2015. Full stop. It is the case of the petitioners that they were found to be qualified in the physical efficiency test consisting of 100-meter race, high jump, and long jump. Full stop. However, they were not selected for the Viva Voce, and accordingly, in the select list published on 24/1/2016, comma, their names did not figure. Full stop. Para. Sri Datta, the Learned Council for the petitioner, has submitted that his client belonged to the OBC category. MOBC category, and had completed the elimination race of 1.6 kilometer within the prescribed time of 7 minutes. Full stop. He had also qualified the physical efficiency test consisting of 100-meter, comma, high jump and long jump. Full stop. It is the principal grievance of the petitioner that there was no prescription in the advertisement of shortlisting of candidates for Viva Voce. There was no written test.
No.
Viva Voce.
point out one thing, sir. On this, my lord, issue matter, by raising some other grounds, my lord, another repetition was filed. And, my lord, this honorable court, my lord, while disposing of that repetition, my lord, the order that, however, the authorities will also proceed with the appointment of 104 post of constable under the All Assam Forest Protection Force in terms of the selection list after making necessary rectification of the same as observed and directed above. So, my lord, thereafter, my lord, that part, my lord, what had happened?
What is the WPC?
WPC, my lord, 4532, 2016.
Have you annexed it?
My lord, this was subsequent. I have not,
No, no, the in additional affidavit?
not filed.
কি করো the principal? Full stop. He accordingly submits that submits that necessary interference be made and the candidature of the petitioner be duly considered. Full stop. Ms. Shankar, the learned counsel for the petitioner in the other case, while endorsing the submission of Sri Datta, has also submitted that having found qualified in the physical efficiency test, there was no reason not to include the petitioner for the viva voce. Full stop. She has also submitted that on 24/1/2016, a select list was published for candidates to appear on viva voce to be held from 8/2/2016. Full stop. Para. Per contra, Sri Gogoi, the learned standing council, has submitted that the petition has been structured on an erroneous presumption. Full stop. It is submitted that shortlisting of candidates to face the viva voce is a part of the recruitment and is not required to be specifically mentioned in the advertisement. Full stop. He submits that unless a process adopted is grossly unreasonable or malafide, such process do not call for any interference when the same is adopted for the sake of convenience and to efficiently conclude the recruitment process. Full stop. The standing council has also referred to the affidavit in opposition filed in both the cases. Full stop. The aspect as to why the petitioner's name did not figure in the shortlisted candidate has also been stated specifically. Full stop. It is stated that while the cutoff mark for the category of OBC/MOBC is 24, the petitioners got
21.5.
And the second one?
The second one, the doctor,
Datta is the first petitioner.
Yes.
First
Yes,
case,
yes.
21.5 and so respectively.
and the second is 12.5
And 12.5
out of
respectively.
35.
Respectively. That's right. Full stop. It is submitted that the cutoff mark has been calculated vis-a-vis by taking into account the number of candidates and the total marks which was stipulated as 35. Full stop. He has also submitted that there is no malafide alleged and full stop. The standing council has also highlighted the aspect that while the shortlisting of selected candidates has been challenged, comma, none of those candidates have been made parties. Full stop. Para. Sri Datta in his rejoinder, Sri Datta Learned Council in his rejoinder has however submitted that in a subsequent writ petition filed WPC 4532 of 2016, comma, what was
My lord,
interim? What was the order?
my lord, order was that however the authorities will proceed with the appointment of 104 post of constable under the All Assam Forest Protection Force in terms of the selection list after making necessary rectification of the same as observed and directed above.
What was the case there? We did not know. The order in which, though there was a direction to fill up the vacant 104 numbers of post, comma, the same was to be done after carrying out necessary rectification. What's the para?
After what was the status?
The Learned Council has, however, submitted that he is not aware as to the development which had taken place thereafter. Full stop. Para. The rival submissions have been duly considered. Full stop. Para. The entire crux, fulcrum on which the petitioners have based their cases is their qualification in the physical efficiency test, which consisted of completion of 1.6 kilometer run within a stipulated time of 7 minutes, comma, high jump, comma, long jump, and what was it? What was it? Long jump and third one?
Long jump, high jump, 100-meter sprint.
And 100-meter sprint. Full stop. Though it is claimed that the petitioners had qualified, comma, it appears that marks were allotted and out of total 35 marks, comma, cut-off marks were also prescribed for various categories. Full stop. From the affidavit in opposition filed in these cases, comma, it reveals that so far as OBC, MOBC is concerned, comma, the cutoff mark was 24, full stop. It is also revealed, comma, as observed above, that while the cutoff mark was 24, comma, the petitioners had secured 21.5 and 12.5 marks respectively, full stop. Shortlisting of candidates to be called for viva voce per se cannot be held to be illegal or improper, full stop. This rather, comma, in the opinion of this court, comma, such shortlisting would be necessary for the exigency of completion of the recruitment process in a smooth and fair manner by taking into account the number of vacancies and the total number of candidates who had applied for the said post, full stop. The matter would have been different if the marks secured by the candidates were above, secured by the petitioners were above the cutoff marks, which is not the case. Full stop. The aspect of the selected candidates whose names figured in the shortlisted names figured amongst the shortlisted candidates is also a relevant consideration. Full stop. The aspect of the order passed in 4532/2016 has also been taken into consideration. Full stop. Though it is submitted that the petition that the recruitment was directed to be completed by filling up the post by undertaking necessary rectification, comma, a bare look in the order which has been placed before this court would show that the petition has been held to be devoid of merits, apart from being not maintainable for not impleading the selected candidates. Full stop. Para. In the considered opinion of this court, comma, the said order would not come to any aid of the petitioners in these cases. Full stop. In view of the aforesaid discussions, comma, both these petitions stand dismissed. Okay.
Deeply agree.
Clear, Lordship. My lord, on last occasion, Lordship, I had a matter and instruction was sought for Mr. Nandi, my lord. So I am informed, my lord, that Mr. Nandi will not appear, my lord, and different counsel will appear. So, A. Ganguly, my lord.
Mr. Ganguly was here in the
Yes,
morning.
he was here in the morning, my lord.
17 matter, why is he not there? No one on behalf of Mr. Ganguly. He was there all along.
He may call to him.
Huh?
I'll try to call him.
Though the petitioner is represented by Sri G. Alam, comma, there is none to represent the respondent bank. Full stop. Sri Alam has, however, informed that the counsel whose names appear in the cause list for the bank would not appear, and there is some change. Full stop. Para. In the interest of justice, matter is adjourned to be listed on Thursday next. Not this Thursday, next Thursday.
Obliged.
Very pleased, Your Lordship. My lord, there is an order on 15th of February 2024. This honorable court had proposed a course of action.
15th of
15th of February 2024. The honorable court suggested a course of action to dispose of the matter in that line. Only the private respondent's reaction was to be ascertained. The departmental counsel.
Who is for the board?
Mr. S.T. Kyle was appearing for the board.
Yeah, for the board. How have you considered the order of 15 Mr. Datta says that though he had challenged the private respondent, if the same benefit is given from the same date.
No, not from the same date. And therefore, the Honorable Court suggested that the matter should be sent back to the respondent's authorities to consider the claim of antedating the promotion. And if there is something decided, the only grievance of the private only aspect of challenge, principal challenge is on respect of delay. Because the promotion was passed sometimes in the year 2014 and the writ petition was filed in the year 2018. So delay was a ground which is
No,
very
you
strong.
said that on the date when your private respondent was given promotion, if on that date.
Yes, if on that date.
That is the same date we are
yes,
saying.
Yes. So to this suggestion, Miller, the private respondent counsel had said that he would require some time to seek instruction.
Private respondent is the board.
No, private respondent is one represented by Mr. K.N. Chaudhary.
No, he will not have any objection.
In fact, it was his objection. The board is otherwise agreeable because 15th February order, your lordship will see, Mr. Kyle said that they don't have any difficulty. The last penultimate paragraph, Mr. S.C. Kyle, the responding to such argument, Mr. Gautam Learned Counsel representing the respondent number 5. He may be granted some time to.
No, for remanding back, they'll still consider. We thought that he had already considered.
No.
That he'll still consider. His concession was only up to a remand.
Yes.
That they'll consider a case whether you can be given promotion from the date when private respondent was given the promotion.
Yes.
To which Mr. Chaudhary had objected.
No, he said that the counsel said that he'll seek instructions.
No, Mr. Chaudhary had objected.
No. On this day, Mr. Chaudhary was not present.
Okay.
The junior who was there, he said that so far as the question of granting benefit from the anterior date is concerned, on that matter, he will seek instruction. And Mr. Kyle said that he doesn't have any difficulty if it is demanded.
Kakoti, what difficulty will he have if he has the...
Because ultimately it is the department who has to consider.
18 matters. What to do?
Because promotion, on the merits of the matter, promotion, we have been able to show that the promotion was granted illegally. That is our stand. But the principal.
Well, Mr. Kyle is from up there. Let's have it something. Is he there or not in the court? He's on legs. Okay, we'll have some other day. Mr. Chaudhary, here's another matter. If he comes, we'll have the other matter.
In that case, your lordship can.
While Sri S. Datta Learned Senior Counsel for the petitioner is present, a prayer for adjournment has been made on behalf of Sri S.C. Kyle Learned Counsel for the respondent number 1, 2, 3, 4, as well as Sri K.N. Chaudhary Learned Senior Counsel for the respondent number 5. Tara, list this case for hearing on
5th of September.
Madam, 5th September is okay? Or 3rd of September? Tuesday? Okay.
Or 3rd of September.
3rd September. Okay.
Published.
15. Yes.
That's good.
Yes, what is this?
Yes, sir. Before going deep into the matter, lordship, and to approach the fact, lordship, that followed by the FIR, lordship, against the petitioner, the respondent has taken a disciplinary action.
You are a government employee?
Yes, lordship.
How are you posted? Your name is B. Sinha?
Yes, lord. I'm a CRPF personal, lordship.
CRPF?
Yes, lord.
What post?
At present, Havildar, lord. Rank Havildar.
Havildar,
Yes, Lord.
CRPF.
Yes, Lord.
Then what happened?
Yes, Lord. My family. Was kindly come to page number 17, Lord. That is
70.
17, Lord. 17.
17.
Yes, Lord.
Okay,
Annex 1, Lord.
please, yes.
Followed by this FIR, Lordship.
FIR is lodged.
Yes, Lordship. By
What is your name?
yes, Lordship. My name is
Pranjal Das.
yes, Lord. Yes, Lord.
FIR 21-3.
May I read up, Lordship?
Yes, yes, please.
My humble request is that last night there is so and so about so and so when I was not at home. Mr. Pranjal Das, I'm the petitioner, situated at Roria, without any permission entered my house and put off the lighting lamp and suppressed the mouth of my wife with the ill intention. He somehow forcefully escaped from the grip of the offender and shouted loudly. The miscreant then ran away. Sir, my humbly request is that kindly investigate the matter and punish the offender. This is the appellate. And Annexer 2 is the lordship. Is page number 20, Lord.
Yes.
This is the statement of the victim, Lordship.
Page?
May I read it, Lord?
Page?
Page number 20, Lord.
20.
Yes, Lord. May I read it, Lord?
Yes, please.
The statement of Rekha Datta, so and so, under section 164 CRPC, so and so. Lordship, may I read the relevant portion?
Yes.
I researched. So and so on evening on 21/3/2007 at evening, I was at my home. And at that time, my husband went to shop. And at that time, at about 8:30 evening, Pranjal Das, there is the petitioner lordship, came to our home. I was inside the kitchen room and cooking food at that time. And our minor son and daughter were also at home. When Pranjal Das was sitting at our home, my husband returned home from shop and suddenly opened the door, for which lighting lamp kept near the door fell down and the lamp turned off. My husband entered home and saw Pranjal Das, and he started hue and cry with a doubt that the Pranjal Das was doing something immoral activity with me. And at that moment, my husband was having alcohol. Seeing hue and cry, Pranjal Das left our home. After that, my husband lodged complaint before the police station that Pranjal Das was trying to do something immoral activity with me. But Pranjal Das did try to do any immoral activity with me, and husband falsely lodged the complaint. Pranjal does stay near us with his family in a rented house.
Okay, we have read this.
Yes, Lord.
We have read this. Next.
Yes. Now, Lordship, kindly come to page number 23, Lordship. This is annexure number 3, Lord.
Yes.
This is the Lordship. Already a departmental inquiry was conducted against me, and a punishment was awarded by the commandant, Lordship, the then commandant. What happened, Lordship? The IGP.
What is the date? 15th of January.
Yes, Lordship. Notice this is the enhancement, Lordship. This is the enhancement of punishment, Lordship. Actually, the original order of penalty was not served to me. Only the enhancement was served, Lordship. That's why I can put annex the original disciplinary penalty, Lordship. That was annexed by my learned senior friend in his affidavit of operation, Lordship. May I read it, Lordship? This is the enhancement, Lordship. Enhancement of punishment, Lordship.
Okay.
May I read it, Lordship, the relevant portion? Lordship, kindly come to page number 24, Lordship.
Page?
Page 24, Lordship. Paragraph number 3, Lordship.
3, yes.
The charges leveled against the constant city are very serious in nature and deserve punishment commensurately. In the instead case, the punishment awarded the commandant. There is the original, Lordship, who give the punishment, Lordship. To the offenses is not found commensurate with the gravity of the offenses committed, Lordship. That's why the IGP, Lordship, therefore, by virtue of the power conferred on me by Rule 29D of CRPF Rule 19, the case has been reviewed. Consequently, a so-called notice was issued to so-and-so, so-and-so to show as why the penalty as shown in paragraph so-and-so not announced. In reply to the so-and-so, the so-called notice to so-and-so has brought out any convincing or extraordinary circumstances which led him commission to the offense charges liable against him.
In his reply to so-and-so, he stated that he committed the offense in question unintentionally and termed as misfortune. It is not acceptable, convincing, especially when he was deployed for duty in operational area. He added further that he is poor facing so-and-so and so-and-so, depending upon his salary income, etc., and prayed for the offenses charged levied against him. On examination of the departmental inquiry proceeding, it is found that the inquiry officer in his report shows that concluded that Article 1 is partially proof and Article 2 is proof. The disciplinary authority agreed with the report of OE with Article so as regard to he find as partially proof. The delinquent in his so with reference to OE inquiry report has agreed to with OE report and pleaded guilty. It is replied that so reference to 611 as he pleaded guilty and stated matter as discussed in the proceeding paragraph. Or through scrutiny and examination of the charges on entire DE proceeding, I found and draw interference, including that he left his duty place while he was detailed for guard duty, so and so on, without the permission of the competent authority. He visited the house of the civilian on so and so advertisement in absence of any male member, and he brought bad name to the CRPF and transit an image of the force as case highlighted by media. The inquiry committed so-and-so has given more weightage and considered the issue related with the criminal charges offences which was inquired by the civil police court concerned as required in the criminal trial. The disciplinary proceedings have been drawn against the delinquent are for aforesaid act listed so-and-so moved act such warrant deterrent punishment. So, Lordship, what happened? Come to the Lordship. The paragraph 6. After considering all pros and cons of the entire case, proceeding final order of is passed by so-and-so with reference to Stockholm's notice as discussed in the proceedings.
Yes, I read this.
Yes, Lord.
2 years have been
yes, Lord.
made to
From
5 years.
It's been 5 years, 2 years to 5 years, Lordship. Now, Lordship, finally come to the provision of the CRPF, Lord. Finally take on the
CRPF rule.
yes, Lord. CRPF, Lord.
Okay, Yes. Yes.
Yes, Lordship. Lordship, kindly come to page number, oh, sorry, Lordship, section 28, Lord. Section 28.
Section.
Yes, Lord.
Your
Rule, sorry, Lordship. Sorry.
rules.
Pardon, Lord. Rule 28, Lord. "27 is the Lordship procedure for the award of punishment, and 28 is Lordship appeal, Lordship, and 29 is revision, Lordship. One must come to a revision, Lordship, need to exhaust the Rule 28, Lordship. That is appeal. Either both case, Lord. Either for me or for Lordship. For the official, Lord. To exhaust the after 27, Lordship, to come to the revision provision, Lordship, one must exhaust appeal, Lordship, rule appeal, 28. But that was not applied by IGP, Lordship. That is respondent number 3, Lordship. Respondent number 3, while passing the enhancement order, that is from 2 years to 5 years, Lord. 2 years to 5 years. That is not possible, not find a single word of appeal in the entire proceeding in the order, Lordship. Enhancement of order that I have been given a chance of appeal will find any word of appeal, Lord, in this entire procedure. Entire order, Lord. Chance of appeal was not allowed. Now, Lordship, I will take draw your attention to page number, Lordship.
Yes.
Yes, Lordship, page number 33, Lordship. And action number 4, Lord.
Yes.
Yes, Lordship. This is the Lordship order passed by the trial court, Lordship, for the pending of my criminal case against me, Lord.
33.
Yes, Lord.
Yes.
That is, Lordship, may I read, Lordship? Case record is put up today. Peruse the case record. It appears on perusal of the case record that the notice has been received by the informant himself, but he was absent on the date fixed. Accordingly, view the above, I deem it fit to accept the efforts so submitted by the IO considering absence and no objection of for informant. Case is disposed of. So, Lordship, at present, I have no criminal case against me, Lord. Now I'm coming to the point, Lordship. Now, Lordship, kindly take on the affidavit in opposition filed by my third senior court. Kindly, Lord. For the page number 22 of the affidavit of opposition. Page 22, Lordship. There is an extra 3, Lordship, of affidavit of opposition.
Yes.
Yes, Lordship. Kindly come to page number 33, Lordship. I'm taking the relevant portion, Lordship. Point number 4, Lordship. Mary, Lordship. Page 23, Lordship.
23.
Yes. Paragraph number 4, Lord.
Yes.
I read the I have gone through the DE proceeding as well as reply of the delinquent on so and so, relevant that IO has been Article 1 as partially proved due to the following reason. Because the wife of so and so complains so and so that the delinquent did not take any attempt to rape her in the absence of her husband while she was at a residence so and so. Rather, she alleged that her husband has raised false allegation against the delinquent under influence of liquor. She has also said that the delinquent has visited her house also being a neighbor without any intention. In fact, the moment her husband went inside the house after running from his shop under influence of liquor, the lamp of the house went off, resulting darkness in the room. Because of this reason, the complaint had even the delinquent might have raped his wife and lost the efforts of so. This is the statement of the record. As per report as so in charge of police so it was established by the statement of the that the delinquent was not involved in the case. As such, he was released on care bond. Now, Lordship, this I want to draw that before coming drawing of the disciplinary proceeding, Lordship, everything is in the knowledge of the opposite party. I mean to say, respond, Lordship, that the offense which was not committed by me, Lordship, that was forcefully entrusted to go more such punishment, Lordship, because FIR was lost in 22 of March 2007, 23 March of 2007, 164 statement, Lordship. Then 19/4/2007, Departmental inquiry was conducted, Lordship. 19/4/2007, Lordship. Departmental inquiry conducted. Within this period, Lordship, all the respondents have the knowledge of the incident. Now, Lordship, I want to come to say that I have made some environment, Lordship. Section 28, they definitely fail to give any appropriate reply, Lordship. However, Now, Lordship, they said that because of my conduct, a bad name has been brought by media and so, Lordship. These all are the statement, Lordship. Nothing annexer has been annexed, nothing paper cutting has been annexed against to prove such and such against me, Lord. Not single opportunity has been allowed to me, Lordship. They directly they brought the proceeding and kept me suspension. Even Lordship, they don't furnish the original punishment, Lordship, punishment order. They directly give me the enhancement of punishment order, Lordship, in my hand. Now, Lordship. Now, Lord, kindly come to page number. Lordship, kindly come to the affidavit of page number 2, Lord.
Page 2.
Yes, Lord.
Yes.
Lordship, paragraph number 4, below, Lordship, 9.
Yes.
From below, Lordship, 9. Yes. During his off time, Lordship. During his off time on so and so about so and so, Lord. It was mentioned that it was off time. If, Lordship, I have left the duty on my duty over, Lordship, they should have annexed such kind of document or any paper, Lordship, that reflected that I was in the on duty, Lord. If that is to be called to be correct, Lord. Because a person has been entrusted to a duty, Lordship, somewhere there should be a written that you have been allotted for this and this duty on that particular date. But nothing has been allowed, Lordship. Nothing has been made, Lord. Directly, they have, based on the LSFL, Lordship, they have given all this and right from 2007, Lordship, nothing enhancement has been awarded. Even, Lordship, after following of several representation, they just before filing of this petition, they promoted to me Havildar, Lordship. Otherwise, these days there were nothing to promote regarding with this paper. And Lordship, I have a judgment to in this regard, Lordship. So that may kindly might help Lordship also. That is GM Tank, Lordship. GM Tank versus State of Gujarat and other, Lordship. So here is mostly discussed about identical of disciplinary proceeding and the criminal case, Lordship. So it is given to the judicial order, Lordship. I want to emphasize on paragraph number 30, Lordship. 20, 30, 31, Lord.
Yes.
Yes, Lord. This is my one. And yes.
Mr. Bora?
Wait. Allegations are very serious. So it is finally submitted. But allegations are very serious. He was on guard duty first and foremost.
Mr. Sinha, have your seat. Mr. Bora, just tell us one thing. On the seriousness of allegation, what you are saying, let us accept. You had imposed the punishment. Now the rules which are holding the field give the provision for filing departmental appeal and thereafter revision. Now the disciplinary authority, after completion of the inquiry, had imposed the punishment of reduction of rank in by two stages. He did not file any appeal, or he is not aggrieved by that. He is aggrieved. He is confronted with an order by which the penalty has been Enhanced.
So,
Under what powers do you enhanced?
so since the appellate authority has been empowered to enhance,
Appellate authority in whose petition?
suppose the disciplinary authority committed error in imposing punishment.
Yes.
The matter has been sent for review.
Who will send? Did he avail the opportunity, avail the provisions of appeal? Did he file an appeal?
He did not file.
Then how did the appellate authority come into jurisdiction? How did he assume jurisdiction? Suo motu powers cannot be exercised. That is on the enhanced penalty. And second is on the penalty itself. The entire charges are very serious, no doubt. But the criminal case was triggered by an FIR lodged by the husband of a woman. In her statement, she says that nothing of this thing has happened. Nothing has happened. Criminal case ends in a FR, accepted. Final report accepted by the magistrate. Matter ends there. We are not saying that you are bound to. You do not have the power to proceed. You can proceed, but when there are no materials at all, when the main victim has said that nothing has happened, what would be the materials to come to a conclusion that he is involved with this kind of allegations? How did you help the charges to be proved?
He pleaded guilty for the IO.
Inquiry officer. Okay, let us not at this moment deal with the penalty imposed by the disciplinary authority. How was it enhanced? By what procedure?
While reviewing the
why review? Who will review?
Section 29
50?
Section 29.
Rule 29.
Sorry. Rule 20.
Yes, please read.
Revision.
Yes, a member of the force whose appeal has been rejected. So the revision starts with the premise that an appeal by the delinquent has been rejected. Now, where was the appeal? Was there any appeal preferred by him? Then, how do you exercise revision power suo motu in absence of such powers in the rules?
Of course, this rule also I fairly submit merely on the allegations, CS allegations. He also have been.
No, you may proceed with the disciplinary proceeding on the basis of the charge memo served upon him. And you have concluded also the proceeding by an order of penalty by 2 stages. Matter has ended there. He says that he is not even served with the original order of penalty. That's a different aspect. But let us take a different view, that assuming that he has been served and he has not preferred any appeal, he is not aggrieved. Okay, I have been imposed this penalty, I accept. Thereafter, where is the provision for you to enhance it without, when there is no powers of suo motu exercise, no provision for suo motu exercise of powers in that rule 29. And the petitioner has not only challenged the enhanced penalty, he has also challenged the initial penalty.
Yes, sir.
15/1/2008 is not the only matter of challenge. He has also challenged 3/9/2007. And 3/9, he says that it was never served upon him. You have the proceeding. Proceeding, you have to, if you are saying that he had, there was an admission from him. Let us see the admission. Where?
2 weeks time.
These are all matters, Mr. Bora. He says that you have admitted in the disciplinary proceeding, in the
No.
inquiry.
No. That ought to have been annexed with the affidavit of the court. Nothing has been.
What have you stated, Mr. Bora, in your opposition? That he has. Let us see the charge memo, Mr. Sinha.
Yes, Lord.
Where is the charge memo?
Yes, Lord. That is in the page number 22, Lord. It is the original charge report.
20?
22, Lord.
22.
Yes, Lord. This is the original charge, Article 1 and Article 4.
22 of the affidavit of opposition.
Yes, Lord. This was not served to me, Lord.
Charge memo, how did you face the proceeding then? It was served upon
No,
you.
Lord. Directly to the Quarter Guard, Lord. Itself. After that, suspended. Lord.
That is not the charge memo.
This is the
This is independent proceeding was
Yes,
inquired. Has been ordered. So, this is the charge memo. Okay.
Page 13 of the affidavit of opposition.
No, this is not the charge memo. This is the order of penalty.
Yes.
Where is the charge memo?
This is regarding admission on his part loss. Page 13, loss can be used for type. Page 13, paragraph 5.
See, the article number 1 is nothing to do with molestation.
Yes.
It is visiting a house of a civilian in absence of a male member.
Yes.
That is the allegation. That for that you may have to face the proceeding. See, so far as the second charge is concerned,
Yes,
the attempt to rape the wife,
yes, Lord.
that part there may not be any evidence because the victim wife has made a statement that nothing of this
Yes.
sort has happened. But the fact that you had visited the house.
Lordship, as per allegation, Lordship, I have left that. I have visited the house of the victim on my duty hour, Lord. That is the main rule.
No, even outside the duty hour, you
Yes,
cannot
Lordship.
visit in absence of a male member.
But Lordship,
You cannot.
Lordship,
You are a
this
member of
only is the
discipline force.
Lordship, since I'm the neighbor of that fellow, nothing bad intention.
See, if there is no complaint,
Yes.
nothing will happen. But if
Yes.
there is a complaint or if somebody detects it's a misconduct, there are rules in the discipline force
Yes,
that you
Lordship.
cannot even stay alone. You have to stay with your family
Yes, Lord. But
in the quarter.
Lordship, initial that was put under section 11, Lordship. That was under section 11, Lordship. That is,
Two charges.
yes, Lord. Under section 11, Lordship. That is when the
One was partially proved, and Article
This-
2 is proved.
Police Force Act, Lordship. That is minor punishment, Lordship.
Uh,
Her daughter was there, Lordship. But in category Article 1, it's categorically mentioned, Lordship. While he was detailed for guard duty at so and so, Lordship. Categorically, that was mentioned, Lordship. No doubt, Lordship, the victim husband dictated. it was their person, Your Lordship, with bad intention, Lordship. While I was
Reduction
detailed with
of,
courtesy, Lordship.
But
Nothing can be shown, Lordship, that I have been.
this initial penalty was not with, will have the effect of postponing. Will not on increments. Cumulative effect.
Yes, Lordship. Till today, the effect is in the run, Lordship. Till today, since 2007, Lordship. Till today, Lordship. But before
Mr. Bora, even if we do not interfere with the initial order of penalty, lower reduction to lower stage by 2 years, the enhanced penalty
5 years.
5 years, it cannot be sustained.
Regarding the
That is without jurisdiction.
yes, so regarding admission lordship, lordship can produce page 13, 13 paragraph 5.
Of your affidavit.
Lordship.
13.
1. Paragraph 5, last part. In the reply dated production is proposed notice from also Punjab class of 30 petition, CRPF has not brought out any convincing or extenuating circumstances which led him commission of the offence as a trial against him. In his reply dated 28/11/2000, he has stated that he committed the offences in question unintentionally and term as misfortune. It is not acceptable convincing, especially when he was deployed for duty in operational area. He added further that he is poor, facing financial hardship, and the family depending upon the salary, income, etc., and paid for the offences charges leveled against him. Next, paragraph 3. On examination of the tribunal proceedings, it is found that the inquiry officer in his report drawn the conclusion that the Article 1 is partially proved and Article 2 is proved. The disciplinary authority, CO, 35 billion, agreed with the report of inquiry officer with reference to Article 1. As regards Article 2, he finds it as a partially proved. The delinquent in his reply dated 27/07, which refers to the inquiry officer's inquiry report, has agreed with the inquiry officer's report and pleaded guilty. In his reply dated so-and-so, with reference to the show cause notice dated so-and-so, also he pleaded guilty and said matters as discussed in the proceedings paragraph.
Now, this order, which was passed on 15th of January 2008, is under what authority? How did the matter, how was he seized of this matter? How did it come to him? Matter had culminated by passing of the initial order.
He preferred revision. It is not preferred revision.
Where does it say? There is no mention. First, to file a revision as a precondition, you have to prefer an appeal. Where is the appeal?
That's good.
There is no appeal.
Appeal is not possible.
Then how does he assume jurisdiction? The deputy IG. How did the matter go to the deputy IG, the revisional authority?
That was the disciplinary authority imposes punishment. That is again approved by the competent authority. Here in the case, the commanding officer passed the order of.
It is the commanding officer who is the disciplinary authority. He is the person who can impose the penalty.
That's true. This SOCO was 6th of November 2007. Under what authority?
Even they failed to enact that focus order.
29D. 29D, let us see. 29D, you have referred to 29D. Oh, yes, yes, you have a power, Mr. Bora, you are not showing. You're not even showing 29D. D West U powers. D. Please read.
The diagonal for special diagonal
Or the addition.
or the additional diagonal within the zone or the inspector general of the or the deputy inspector general may call for the record and award of any punishment and confirm, enhance, modify, or annul the same or make or direct further investigation to be made to before passing such order. They have been empowered. It means there is no procedural error. Second paragraph of 29D, provided that in a case in which it is proposed to enhance punishment, the accused shall be given an opportunity to show cause either orally or in writing as to why his punishment should not be enhanced. Accordingly, he was served with purpose notice. He punished reply. There also he pleaded guilty.
So Sinha matter is slightly different. There is power.
Yes, but they have said that they have punishment is proposed notice. If I have been served as so cause notice, why we fail to annex that so cause notice with the affidavit of patient?
So cause notice is there first. This is the so cause notice. At page 10 of the affidavit of opposition by the authority who has announced the
Yes, sir. Yes, sir. Beg your pardon.
so cause is there.
Beg your pardon.
You have filed reply also 2811. Mr. Sinha, you have not been properly instructed.
29.
Your file reply, come to page 13. Page 13 and extra paragraph 5.
What's the page number? Okay.
Page number 13 of the affidavit of opposition. Procedural impropriety is not there.
Yes, but
point out this. These are
yes.
all on record. Neither you nor Mr.
But one
Bora
thing is,
pointing
Lordship,
out.
that Lordship, before going to the departmental procedure, Lordship, the respondents were all aware, Lordship, with regard to the fact of the case, Lordship.
See, the allegation
Lordship.
of molestation and rape, attempt to rape, let us forget those. Those are not proved.
Yes, Lordship.
But your subsequent, the other activities of visiting a civilian's house and the male member is not there.
Yes, Lord.
Those are proved, and the penalty imposed appears to be commensurate with such kind of allegation. You belong to a disciplined force. Had it been a case of rape or attempted rape, matter would have been much more serious.
Yes.
That is why perhaps you have not been dismissed, you are still in service. And GM tank, the facts, if you have read GM tank, the facts are different. It is on the same charge and there is an honorable acquittal. You may contend that in this case, there was not even a charge against you.
Yes.
There was no charge sheet. It ended up in an FR accepted by the court.
Yes.
Matter ends there.
Yes, sir.
But the charge in the disciplinary proceeding is not the same charge. It is leaving the barrack and going to a civilian's house in absence of a male member.
Yes.
Forget about the charge of attempted rape, molestation.
Yes, sir.
Only that part is off by the wife's statement. But the visit, the fact of visit is proved.
But, wait.
You can still have a scope to argue on the proportionality aspect, whether the penalty imposed is proportionate to the nature of the charge.
Yes.
Nature of the proved charge.
Yes, sir.
Charges of visiting a,
Yes, sir.
for that should you be penalized with 5 years?
Yes, sir.
That you can argue, you can place decisions.
But
That is the only scope, otherwise
Yes.
there is no scope. Mr. Bora, we are not interfering.
Lordship,
But we may think over so far as the veracity, so far as the severity of the penalty is concerned. Whether the initial penalty could have been sufficient or whether there was need to enhance the penalty.
Yes.
We are not doubting your powers. 29D vests powers on the superior authority that he may call for the records, he may enhance, but
Yes.
before doing so, he has to give an opportunity, which he has done
Yes.
towards the reply also.
Yes.
Procedural part, we are not too much, we don't find there too much of a case. But on the part of disproportionality, he might have a case, but he has not argued. But what kind of penalty is this? Under, it comes under what? Which section?
Lordship is 11, Lordship. Minor punishment, Lordship. There is-
5 years?
There is initial charge was framed under section 11, Lordship.
No. Let us see the
Fourth.
nature of the penalties. What are the penalties?
Yes.
Section,
It's on
rule.
it's Force, Lordship. Force Act. Central is a Force Act 1949. There is 11, Lordship.
Section 11.
Yes, Lordship.
minor punishment.
There is punishment is minor, Lordship. Reduction to rank may read, Lordship.
Minor.
Page 6,
Page
Yes.
6.
And major penalties, where are those?
It's section section 9 and 10, Lordship. More heinous offenses, and section 10 is less heinous offenses.
No, we are not on the offense, we are on the penalty.
Punishment. That's fine. Only 11 is there.
Come to section rule 27.
Yes, Lord. Suspension, Lord.
Rule 27.
Yes. Procedure for award of punishment, Lord.
Dismissal,
20.
removal, reduction to a lower time scale. One stage. This is not a minor penalty, it's a major penalty.
Yes.
Minor penalty is reduction in rank. This is not reduction in rank. It is reduction to a lower stage in the time scale. And this kind of penalty are to be preceded by a formal departmental inquiry. That is why the inquiry was held. Yes, Mr. Bora, what do you say on the severity of the penalty?
Justice being a paramilitary force, Justice, actually he was on duty, not duty. He's not supposed to leave the post without prior permit.
He was on guard duty at
He
that
was on
time.
guard duty.
From where do you say so? Yes, he was on guard duty. The incident happened on 21/3. Okay. We have found he was on guard duty.
Look.
He was on duty from 18 hours of 21/3/2007 to 18 hours of 22/3/2007. An incident happened on the first day, 21/3/2007 at 20:30 hours,
Plus.
8:30 p.m.
Plus.
From 6 p.m. to 6 p.m., 24 hours he was on guard duty.
24 hours. Without any prior permission, he left the place of the party and came to the civilian house.
Now, for that reduction of lower stage with 2 years, I think would have been sufficient. Yes, will you show any decisions on the severity, disproportionate respect?
Yes, for the at present, I don't have in mind.
We'll have it tomorrow. Come prepared tomorrow. Tomorrow we'll finish this. Tomorrow.
Tomorrow.
Today we have to rise. So there's some meeting for majority. Mr. Mukhtar, what is your matter? 16. Hearing remains inconclusive. Kali ki bar? Kali to Budbar, na? List again tomorrow. We'll have immediately after the motion admission. Before the we'll see. We'll have it, but we'll finish it tomorrow. Okay. Mr. Sinha, you said come prepared with this. Yes, Mr. Singh. What is the matter about?
Termination.
Other side, Mr. Doctor. Other side, Mr. Doctor.
Yes, yes.
What is the case?
Time of return. Submitted some false.
Enrollment is what?
He
Enrollment is what?
enrollment as the constable driver, my lord. Driver.
In which force?
Constable Simabal, my
SSB.
SSB as driver. So general after completion of his training, he do that job before here, and after
He had given false documents.
all not false, my lord. Suppose that at the time of enrollment, he has said that he is not married, and no
Criminal conviction
is pending. But after that, my lord, the father-in-law informed the complaint before that, and court of inquiry. He admitted that he has made some false statement.
You were convicted earlier.
Then acquitted also, in appeal where it was acquitted.
Convicted under what? 498A.
498.
And what post? Driver.
Driver, man. At the time of enrollment, the proceeding was going on.
What is the charge? What is the penalty?
Termination.
Termination of service. You are out now.
Now out, man.
What
From
is your age?
2016, from
Age,
2016.
age?
Age, my lord, he is now about 30, I think, man.
No?
Just about 30, my lord.
But why didn't you
Terminated in the year 2016.
why didn't you disclose that you were married?
But after marriage, my lord, she did not live with him, my lord. And moreover, there is no document, but there was this social life marriage, no document at all, my lord. And she was never living with him, my lord. So as there is no document, my lord, he thought that otherwise she is not coming. It is for so many panchayat and all those things that there, she clearly stated. Her father also said she is not going to live with you. And they demanded 10 bighas of land, my lord. Under all the situation, my lord, he thought that, my lord, he has no document also, my lord. And she is not coming to his life anymore also, my lord. So he said, of course it is not correct, my lord. He has said very incorrectly, my lord, that he said that not married, but although he should have said.
That is the only charge.
That is the only thing, my lord.
Only charge.
Sorry, only charge.
And when were you acquitted?
But the conviction was in 15, my lord.
I joined this, call my lord.
13.
In 13, my lord. And at the time of joining, well, there was no criminal case, my lord. Subsequently, when I came, I got the job, my lord. Father-in-law got the information. In the meantime, our relationship finished, my lord. So he got the information that I got a job, my lord. Then he lost this case, my lord. Filed this case, criminal case, 498. Thereafter, after conviction, he sent all these documents to this court, my lord, to the office, my lord.
Then
Then I was acquitted subsequently in the appeal, my lord.
Subsequently, 19, he was acquitted. But at the time of annulment, he was a son also.
Yes, son also, but I don't have any document, my lord. No document was with me, my lord.
Because of
son stays with mother.
Yes, ma'am. Under compelling circumstances, the only thing is that, my lord. Otherwise, it's not that, my lord, willfully he has stayed, my lord. It is not at all willful, my lord, because there is a condition, my lord. It must be willful, my lord.
After the job, you have married again.
No. I am not married, my lord. Not yet, my lord. He's a very poor fellow. My father also recently died, my lord. He's doing daily wage earner, my lord. Earlier also he was doing that, my lord. Somehow he got the job.
As per the direction.
Where was the posting?
In Arunachal, my lord.
Arunachal.
Arunachal.
Where?
Later he came to Bhairab.
Where? Bhairavkunda. Udalguri.
As per the directions, I have received the records and I have the records. But due to the for submission, in record, his father's name, parents' name, and one brother and sister's name is recorded as nominee.
What about the son? Your child.
My lord. He's with the partner, my lord. Birth certificate also not with me, my lord. I can show it to the authority, my lord. Nothing, no document is with me, my lord. That is why thinking that it will not be possible to prove that he's married or he has got son.
No, at that time, if you had said you're married, what is the difficulty? If there was no formal divorce, your marital status is still.
Yeah, of course, it is too much. He's not very educated, man. He thought in that way, my lord, that as he sees not coming, it is final, my lord. She is not coming to his life
You
anymore.
joined as driver.
Driver, my lord. Driver.
What to do? When to do? Tell us.
27th, my lord.
27th.
Tuesday.
Twenty-seventh or 29th. Huh? Take a paucity of time, huh? List on 27th. 27th.
Right. Apply.
Mr. Chaudhary, for which matter? Today we may not have the other side. Yes, madam. Any submissions?
E. Sharma left the court today. What is the matter effect in the first week of September, if possible?
What is the subject?
Subject is lordship with regard to the fact that has been exposed with a major punishment.
You are an employee with the Oil India.
Oil India.
Department proceeding.
Yes, department proceeding.
What penalty?
The major penalty imposed is with regard to the 18 months with withholding of promotion for a period of 18 months.
Major penalty?
Yes, the major penalty of withholding promotion for a period of 18 months. This is the allegation not substantially proved, lordship. This is the allegation of opening of a Tinder account. This is just like Facebook. And some offensive messages were sent to the another employee of you. This is the allegation. It has not been properly proved. But even then, even the inquiry report was in favor of the
petition. A prayer for adjournment has been made on behalf of Sri A. Sharma, Learned Counsel for the Oil India Limited. There are also heard through S.P. Chaudhary, Learned Counsel for the petitioner. Respondent is Oil India. Respondent Oil India.
29, lordship.
As paid for?
29th of.
List for hearing on 29th.
He will not be here. First week of September, any day.
On 3rd of September.
3rd of September.
Okay.
Right.
60. Oh, 6. Item 6.
I'm sorry, my lord, my senior is still on one argument. Only short date may be fixed, my lord. Monday, Tuesday, my lord.
On a prayer made on behalf of Sri K. N. Chaudhary and senior counsel for the petitioner.
Yes.
One petitioner.
Yes, sir.
Matter is adjourned to be listed. Matter is adjourned, full stop. Since urgency has been expressed on behalf of the respondents, comma. List on. List on
20, my lord.
20.
20. As your lord's permitted.
20 we have fixed many matter. 22nd. Let us see on 22nd. Okay?
My lord. Okay.
22nd, 21st to দিব পাৰি বুধবাৰ বিলাক বেছি নাযায়তো আমাৰ ফটাফট হৈ যায় on 21st
My lord.
Wednesday
My interim is there.
interim order passed earlier to continue till the next date of listing.
Hello.
GM take এইটো হিতাতে থাকিব এই চিনহাৰ মেটাৰটো meeting আছে ন